Good afternoon and welcome to the Appellate Division First Department's virtual oral argument. I will now call the calendar. People versus Mark Mcdonald, counsel for appellants, 8 and 2, counsel for respondents, 8. Jones versus McDonald's Corporation, counsel for appellant, 6 and 2. And I believe on the respondent side, we have a pro hoc vici application. Mr. Van Dusen, we will hear you.
Yes, Your Honor. May it please the court, my name is Matthew Van Dusen from Clausen Mailer PC on behalf of the appellees, and we request that my partner Don Sampin be allowed to argue the motions today on behalf of the appellees.
That motion is granted. Mr. Sampin, you have been granted 6 minutes of argument.
Thank you, Your Honor.
You're welcome. People versus Norman Rivera, submitted. McIntosh versus New York City Department of Education, counsel for appellant, 4 and 1, counsel for respondent, 4 and 1. Sterling National Bank versus Friedman, counsel for appellant, 5 and 1, counsel for respondent, 5 minutes. People versus Juan Nieves, submitted. Torres versus Bogota Service, counsel for appellant, 4 and 1, counsel for respondents, 4 minutes. Lipinski versus Extel Development et al., counsel for appellant is 6 and 2, counsel for respondent, appellant W5 Group, 6 and 2, counsel for respondent Extel, 6. People versus People versus Johnson has been submitted. U.S. Bank versus Pacific Investment, counsel for appellant, 4 and 1, counsel for respondent, 4. Arbor Myrtle Beach versus Friedman, submitted. Board of Managers, Alfred Condominium versus Miller, appellant on that part of the appeal, Mr. Greenberg, 4 and 1, respondents, Ms. Boboris, 5 minutes. On the Miller versus Alfred Condominium, appellant Ethan Gobry, 4 and 1, respondents Maria Boboris, 5 minutes. Do I have that right?
Yes, yes, Your Honor, I believe you do.
Okay.
Thank you.
Thank you.
Yes, do.
Thank you. People versus Ronald Santiago is submitted. Posner versus Posner. Mr. Hiller, you have 5 and 1, and respondents, you have 5. First case on the calendar, People versus Mark McDonald, counsel.
May it please the court, my name is Abigail Everett for appellate Mark McDonald. Beginning with the speedy trial issue, 6 years elapsed here between the filing of the felony complaint and the beginning of the trial. And throughout that almost 6 years, Mr. McDonald was in custody at Rikers Island. And the record shows that a large part of this delay, certainly the last 3 years, was because the district attorney's office was having trouble getting their retired detectives into court to testify. Even after judges in March 2014, so that's 3 years in, ordered everybody to go to trial and set a trial date in 6 weeks, the DA's office came in 6 weeks later and said their detective had retired and they couldn't proceed. And again, in May 2015, a judge ordered them to go to trial and they were not able to proceed. So the record, and then in addition, another chunk of time that you see in this case is the changing of assigned assistant district attorneys. And in fact, in the fall of 2014, after the DAs were not ready on that date that I just discussed, they switched DAs. The DA came in, and about 5 months after that date, they'd been ordered to go to trial. When that DA was not in court and the judge inquired, the stand-in DA in the part that day said that he had a note that the new DA hadn't even spoken to the witnesses. So you have on the record clear indication that the district attorneys are not on top of this case. What you don't have on the record really is a showing that they're using due diligence, which is essential. And on top of that, you've got the fact
Counsel,
that
wouldn't it be fair to say that on this record, what can also be said is that it is evident that we have quite experienced counsel on both sides who are engaged on trial actively for many of the adjournments throughout the 6-year pendency of the case. And I am not, by my question, making light of that time.
right.
I just want to be clear that there are a lot of adjournments where both defense or the people's, the ADA assigned was on trial.
Yes, that is true. But as for the DAs, and I think a lot of it is the DA being on trial, we have the proposition that's been recognized by the courts that the district attorney's office has an institutional obligation to not put so much work on their individual assistants that they have to be continually on trial, and as a result, moving back the trials of people who are being held in custody out at Rikers Island for 6 years. Now, and the other thing is they keep on numerous occasions making representation to the courts that they've lost contact with their retired detectives. And in fact, in about 5 years in, you see a representation even later than that, that they've tried to get the head of detectives involved in getting one of these detectives in the court. What you don't see is any indication they ever bothered to subpoena these detectives. I mean, so that's something that now I understand that this is a murder charge, but as you can see recently in the case of Wiggins in the Court of Appeals, even a murder charge where somebody's been in custody for 6 years, as in this case, Mr. Wiggins was charged with murder. Eventually, after 6 years, he pled guilty to manslaughter, but the Court of Appeals still dismissed for a constitutional violation.
This is Judge Owing. I have a question.
Yes, sure.
My notes indicate that on September 23rd, 2013, that the people did represent to the court that they were trial ready.
Yes, Your Honor. But I would
Okay, so-
point out,
So at that point, I mean, it kind of snowballed after that. That was the first time they said they were trial ready, and then everything just went haywire after
well,
that.
it actually wasn't the first time. They did declare ready at arraignment, although in my briefs, I try to suggest that it was a little dubious they were ready because right after motion practice was complete, they asked for a month's adjournment to get the DNA reports. And what's
So you
interesting
mean
about
September 23rd, 2013 was that arraignments? That was an arraignment?
no,
Or that
that's
was
the second time they declared ready.
That
I'm
was the
just trying
second
to
time.
make clear that they had previously declared ready. And
Right.
I was trying to cast some doubt on that first one. But and
Right.
even this one in 2013, the defense lawyer put on the record that the reason he couldn't go forward that day is he'd been told that the DA was not going to be ready. So the record is a little unclear about
Yeah.
that declaration.
So, counsel,
But even so, Your Honor, that's 2013. We're talking about the trial not beginning for another 3 years.
I understand that, but my question is that with respect to some of these cases I've seen, I mean, this is a case where, and Justice Manzanet touched on it by saying that, you know, both sides, I mean, they were all on trial. This wasn't just the people just sort of just, you know, really having nothing to do and just kicking the can down the road. I mean, everybody was working. From what I can gather in the record, there was no sort of, you know, ulterior motive here. Everybody was working hard at their all with trials, and they're doing a whole host of things on both sides. I mean, it's commendable. I mean, look, they're overworked. Everybody's overworked, and you know, and this is an unfortunate, clearly, you know, terrible result here. But it wasn't as if there was some sort of lack of, you know, effort. I mean, everybody was. I mean, you can't argue that there was some sort of, you know, purposeful intent on the people's part about not trying this case, right?
Well, I would ask the court to consider that despite the heavy caseloads on both sides, on at least 2 occasions, judges specifically told them you have to be ready on the next date. So they were on
Right.
notice that this case was going to go forward both in the spring of 2014
And
the
both
spring
sides
of 2015.
and both sides were guilty
No.
of not being ready, right?
No, that's not correct, Your Honor. With due respect, the defense lawyer said, I'll clear my calendar, I'll be ready, but the DA was not ready. And again, in the spring, the defense lawyer was ready. He complained repeatedly. And I do quickly want to transition into the hearing that was held, because when the defense lawyer tried to inquire at the hearing about the reasons for the delay, he had the ADA was testifying, the judge shut him down and said, that's not the purpose of this hearing. So even if this court thinks that there's not enough on this record to reverse on appeal, this speedy trial hearing was deeply flawed. You've got the judge using what's a clearly an inappropriate standard by putting the burden of proof on the defense to show. Yes.
Oh, I'm glad you mentioned that. So what's your response then to the prosecutor's argument that that's not preserved? You didn't move to re-argue before the trial judge with respect to the burden shift, the improper burden shifting.
Well, I thought in my reply brief, I argued that because the standard's so clear and it's in the cases that the defense lawyer had submitted to the judge, both in the Barker case and in the Taranovich case, that clearly state what the burden of proof is, that by that time, the defense lawyer had laid out the standard for speedy trial for the judge. And it's interesting, this judge criticized both sides for having skippy papers, but when the defense lawyer tried to bring out more detail at the hearing, he shut him down right away. It said, that's in your papers. So I think that this hearing is not a fair opportunity for the defense. Before I stop on the Miranda issue, I do want to argue to the court that the detective, I asked the court not to accept the renewed findings of fact by the judge at the reopened Huntley hearing. There really is not reasonable to rely on a statement that a detective made. He didn't testify to a DA, and DA puts it in the report, and the judge decided to opt for that version that Miranda warnings preceded all statements over the testimony of the detective who actually came into court and conceded that he had told the defendant both, you're here because we're investigating this murder last Friday, and can you tell us where you were? That statement is clearly a statement that requires Miranda warnings to a defendant in custody. The detective said, well, I like to build a rapport with people before I give them the Miranda warnings. That's not the appropriate standard. That's clearly not the appropriate standard. And I would ask the court to reverse the finding of that Miranda warnings were given and to suppress that statement. If there are no further questions.
You'll have time on rebuttal, okay?
Thank
All right. Counsel?
May it please the court, Charles Wan for the respondent. As Your Honors have pointed out, the delay here is due to both the prosecutor and the defense attorney heavy caseload at various times. Both either of the attorneys were on trial on other matters and had to have secret adjournments. And also the another reason was the prosecutor had a difficult time obtaining the presence of the retired detectives. One of them actually
Counsel, I asked that question in fairness to paint an accurate picture of some of the time period. But in 2015, the people never answered ready, not once in the entire calendar year. I am looking at every single adjournment, and you attempt to stop the clock. Not that a clock is running on this kind of case, but you try to stop the clock of we're not ready by filing a belated DNA motion 5 years into the prosecution of this case. So while yes, in 2014, it appears back and forth, both the people and the DA assigned to the case were on trial, but I see no effort in 2015 to get this case tried when you were under court order to keep calendar clear so that this case could be tried.
I mean, Your Honor, in 2015, I believe the trial prosecutor pointed out that he was having problems securing the presence of the retired detective. One of them actually provided
was any subpoena ever filed? Was any subpoena ever served on these retired detectives? They don't have a right to hold up a proceeding on such an important case, and while a person sits in jail accused of a crime 4+ years at that point.
I don't think it was that the detectives just absolutely refused to come. One of the detectives, the lead detective actually provided a doctor's note saying that it would be very damaging to his health for him to come and testify. So
he wasn't the only detective. He wasn't the only officer who could provide the needed testimony. And in fact, he didn't testify at trial. So it's evident from the trial that you had another witness, and a witness that apparently the jury believed. So again, that is not an excuse. You had witnesses. There was certainly sufficient evidence. There was no real need for additional DNA. There was no question that this man was at the party.
Well, the detective who had the for the doctor's note, he was the detective who was present during the lineup. So his testimony, the prosecutor, I believe, must have believed was necessary for the Wade hearing. The detective who testified at trial, he did not take part in the lineups. He could not provide any testimony at the Wade hearing on how the procedures, on how the such as the lineup fillers were acquired. So at the Wade hearing, the only person who testified was the eyewitness. We did not have any police testimony. So I think it's understandable that the prosecutor wanted to secure the presence of the case detective who. So
we keep a man in jail for a year while we try to make that happen? That's your argument? That's a prosecutor's trial strategy at what is a better lineup for their trial witnesses is sufficient basis to keep somebody incarcerated on a pending charge on what was then going on 4.5 years. Because all of this is in context, right? 4.5 years had already elapsed.
It definitely would have been ideal for the case to have gone forward earlier, but unfortunately, due to timing of everything with trying to obtain the witnesses to testify and the scheduling, it took longer. But the other one thing I want to point out is there was no, I mean, yes, the defendant was incarcerated, but there was no prejudice to his ability to present a defense. There's no argument that any defense witnesses disappeared or any of the defense witnesses' memories faded and were not able to provide any kind of information at the trial.
Well, sir, I'm sorry, but isn't an observation by the suppression court at the 2016 suppression hearing that, well, Detective Garcia, I find him credible, but look, his recollection may be a little fuzzy because of the passage of time. I mean, wasn't that observation that maybe recollections fade a bit with time? Wasn't that an even more apt observation a year or two later? I mean, there's naturally people's memory tend to fade over time. And we're not talking about the difference of a year or two. We're talking about 6 years. And it seems as though that we're giving more weight and more worry to whether a detective would be inconvenienced by the rigors of cross-examination than rather whether a defendant's constitutional right to a speedy trial is vindicated.
No, and Detective Garcia's memory fading, it actually was, I would not say I would say it actually prejudiced us, the prosecution, more than the defense, because his testimony on what was said, how he questioned the defendant, and whether his statement, whether there was a Miranda violation or it actually affected the people's case on whether the defendant's statement subsequent statement could be admitted at trial, because his memory being faded and him having to rely on his DD5 as to what kind of question he asked. I would not argue to prejudice defendant. I'm not arguing that people's memories do not fade over time, but here there's no any kind of reason to believe that defense was prejudiced in any manner by the delay of the time. And as to the detective's testimony, the hearing court heard the Detective Garcia's testimony and initially did credit it, found that his question was basically just a yes no question. All Detective Garcia really asked was the defendant, is he willing or is he able to say where he was the night of the shooting? It would just mean merely a yes or no question.
That's it. Just confirm your presence at the crime scene. I mean, come on. This isn't an innocuous question. This question is intended to get to the defendant ultimately making a statement that inculpates him.
Your Honor, I mean, the hearing court found that it was actually not prejudicial because all he said was he was at the party. He never said he was there at present at the time of the shooting. So as the hearing court found out, it was not inculpatory at all, because all he really said was, yes, I was at the bar, at the makeshift bar at a club. He never said what time he was there. He did not say he witnessed the shooting. There were a lot of people there. So him just being at the club does not necessarily mean he's actually the shooter, because there's other people there. He did not say, I was there alone at the time of the shooting. So there's nothing inculpatory about what he had said. And that's one of the reasons why the hearing closer found, regardless of what Detective Garcia's testimony might have been, that there was attenuation because defendant did not say anything prejudicial before the Miranda warnings were given. If there are no further questions, people request an affirmance. Thank you.
Thank you. Okay, counsel, you have 2 minutes on rebuttal.
Yes, Your Honor. On the last point about the significance of the statement, that the admission that he was at the party, this was a devastating admission, because when you look at the testimony at trial of the eyewitness, he was very inconsistent. He initially told the police, he described the person, I believe, as a black man. This is somebody that he later on testified at trial that he knew well. So there was really some question here about the credibility of this witness. But once the DA was able to introduce his statement that admitting he was at the party, that significantly bolstered the people's case. So I don't think that we should belittle the negative significance of this statement that was brought out at trial. The other thing about...
I'm sorry, counsel. This is Judge Shulman. I have a question. In analyzing the Taranovich factors, we can agree that the delay is not the sole factor, is one of the 5 factors, correct?
Correct.
Okay. We can also analyze the gravity of the charges. No doubt that a murder 2 charge is very, very grave, to use that word that was actually used, I think, in Wiggins. You would agree?
Yes.
So then you go to the 5th factor that addresses prejudice. Did the 6 years prejudice the defendant in being able to mount a defense? And putting aside your question about the burden that you argue was inappropriate apply, but in analyzing the prejudice, would you agree or disagree that the defendant had the ability to bring in the witness Brown to testify about any exculpatory information with respect to the ID, that the defendant had that ability? Would you agree with that?
I would agree that Brown was available, although he was certainly reluctant and flip-flopping. But Brown isn't the only issue on prejudice, because when you've got a delay of 6 years, the reason the courts presume prejudice with such a long period of time, and in fact, they presume prejudice after even a year. The reason you presume prejudice is because so many things have changed, as Judge Hagan questioned, whether or not memories changed, but also the ability just to investigate the case at that point and to find people who still remember. So whether or not the one witness that the hearing was about was still available and could have been subpoenaed, that's not the end of the prejudice issue.
But that appears to be a real focus, both when you read Judge Torres' decision and then you read Judge Greenberg's decision. I mean,
right.
Both,
it was a focus.
just bear with me for a second.
Sure.
Both seem to acknowledge or make a point of saying that both the defense and the prosecution, forgive my word, schlepped in this case. They both seem to share it based on the record presented. Both sides don't seem to have a real handle on really being ready till maybe when Mr. Smith comes on board in 2015 and actually is on record saying, I'm following the court's rule, I'm not having any trial. But until about that time, both sides seem to say, I'm really busy, as acknowledged by my
Honor, Mr. Smith came out in
so my point is, I'm sorry. So my point is that both sides were busy legitimately, and then we seem to be focusing on real prejudice and analyzing whether about the Brown witness, and again, bringing in Mr. Scallon and the whole gestalt below. So this is really markedly different than Wiggins. I mean, Wiggins really only had one side, the prosecution trying to get the co-defendant to testify against Wiggins and that whole period. And it's not quite the same kind of record.
I don't agree with respect, Your Honor. First of all, it was 2014 when the defense counsel was setting aside his calendar. So that's a whole another year. And the other thing is their witness, although he was available, he had flip-flopped. We can't assume. Originally he had told them that he was going to be a supportive witness. So although he could have come in, what the judge found below was his credibility had totally been destroyed, because initially he took one position, but now he had undercut himself. So both sides were prejudiced by the fact that so much time had passed and he was taking different positions. I don't think we could assume that that's what would have happened if this case had gone to trial immediately. And I really don't agree, unfortunately, with the proposition that both of the sides were just sort of schlepping and not doing their duty. Yes, there were instances where the defense counsel was on trial, but there were also significant times when the court said, be ready, we're going forward, and the defense lawyer cleared his calendar, he was ready, and the people did not. So
Thank
unless there are any other further questions, I ask for dismissal. Thank you.
Thank you so much. Okay, counsel on Jones versus McDonald's Corporation, Mr. Parker.
Good afternoon, Your Honors. May it please the court, Glenn Parker from Parker Hansky on behalf of the appellant Dustin Jones. Your Honors, the lower court committed several mistakes of law when it dismissed plaintiff's action for lack of standing, as well as for splitting a cause of action. Going to the standing issue, there's a threshold question based upon the Court of Appeals decision in U.S. Bank as to whether standing is even relevant to non-governmental action. This action is a private individual against a private corporation. It does not involve governmental action, and per the Judge Wilson's statements or concurrence in U.S. Bank, standing should not be an issue here.
Mr. Parker,
Yes.
This is Judge Gonzalez. What nexus do you find between the restaurant, the lack of access to the third floor, and to the plaintiff? Did the plaintiff ever visit or use the restaurant?
Sure.
I don't see anything that indicates that he was a patron of the restaurant in any way. Is that dispositive in any way here?
I'll answer that question right now. In the complaint itself, as well as in the federal court complaint, what happened was the McDonald's premises at issue had accessibility barriers even at the front entrance. So plaintiff couldn't even get in a safe and effective manner. During the federal court litigation, they finally took care of most of the areas, but there is testimony, I'm sorry, not testimony, but within the pleadings, plaintiff did visit, plaintiff attempted to get in, and he was deterred by barriers. Being deterred by the barriers that exist there doesn't require.
I'm sorry, you're talking about the entranceway, or you're talking about the fact that the elevator to the third floor was removed and now a lift was substituted?
Well, actually, what happened was there was an elevator that had existed in this building, and that was removed in 1994. They had no accessible means of vertical access until 2015. And
yes,
one thing
so
to understand.
My question, if we can just go back to my question, did the plaintiff ever enter this restaurant?
No, he was not able to because of the accessibility barriers, and he was also deterred.
How did he know? How did he know that there was no access to the third floor?
He didn't know until the litigation itself, but he knows, and that's actually permissible even under federal law, that once you encounter one barrier, which the barrier that he encountered was the entrance barrier, and those entrance barriers are identified in the federal court action. Once you're deterred from that, you have standing, even under the federal standard, you have standing to remediate all the barriers. The whole idea is that you don't want to have piecemeal litigation. You don't want to have the plaintiff trying to getting in, and then suing for that violation there, and then finding out a year later that there's another violation there and suing again. You want to have it all done in one action, and that's actually under the more onerous federal standard that's articulated in Chrysler versus Second Avenue by the Second Circuit. So the plaintiff has gone to the premises, has attempted to go in, but he has been deterred because of the accessibility barriers at the front entrance, as well as the lack of accessibility to the third floor. Now, with the third floor, what it is what you need to understand here is that the first level of this restaurant does not have any public seating. So the only public seating that they have is on the second floor. And that wasn't accessible to the plaintiff until 2015. The issue here has to do with the accessibility to the third floor. But again, this was a motion to dismiss, so we're not actually getting to the merits of that claim itself. The issue really here has to do with what the lower court did in terms of dismissing plaintiff's action based upon federal U.S. constitutional standing requirements that have no applicability in New York State court actions. In New York State court actions, the applicable test is the zone of interest test, articulated by the Court of Appeals and Society of Plastics. Now, the zone of interest test is fairly simple. It's, do you have an injury that falls within the zone of interest protected by the statute? So here we have is something very akin, and I believe that this case is very similar to the case of that this court decided last year in Center for Independence of the Disabled versus Metropolitan Transit Authority. It had to do with people with disabled persons not being able to use the subway system because of its inaccessibility. And there, that was considered a violation of the applicable statutes that are articulated by plaintiff in this litigation here. So the plaintiff is protected by the statutes. You cannot dispute that he is disabled and that the Mcdonald's is a public accommodation. And
All right, counsel, you'll have time on rebuttal.
Thank you.
Thank you. All right, Mr. Sampson.
Yes, may it please the court, Don Sampson on behalf of the respondents, Your Honor. In response to the question as to whether the plaintiff ever visited the restaurant, the answer is no, at least according to the complaint. There's no allegation that he did. And in his reply brief, Mr. Parker comes back and argues, well, he really did. And he points to various allegations in the complaint where that simply dance around the issue. There's no allegation he actually visited the restaurant. He argued here that the problem with the trial court.
Does he have to?
Your Honor, all of the cases the short answer, yes. And under all of the cases that he cites, that where the issue of standing is raised and decided in favor of the plaintiff, the court found that the plaintiff had visited the commercial establishment in question and or lived in the immediate vicinity of the commercial establishment, and none of those allegations are present here. He simply fails to allege a sufficient relationship with the restaurant to establish standing. That's what the trial court held.
Counsel, your adversary indicates that during the course of the federal litigation, the plaintiff learned that the third floor was inaccessible. What say you?
He learned that I guess I don't know when he learned, Your Honor. It may have been it was during the federal litigation, as I understand it, because he made that claim in the federal litigation. He made the claim that one of his disability violations was lack of access to the third floor. So yes, he made that claim as part of the federal litigation. Yes, he talks about the Society of Plastics case. The test for standing is not limited to zone of interest. The Society of Plastics case specifically talks about injury in fact as well. And that's what the plaintiff failed to allege in his complaint here.
Well, the question is also whether he was an aggrieved person, right? So is the fact that he uses a wheelchair, does that automatically make him an aggrieved person under the city HRL?
It does not, Your Honor. The fact that he is the fact that he is a wheelchair user potentially puts him in the position of being an aggrieved person, but it doesn't make him an aggrieved person. He has to also establish injury in fact, and he hasn't done that. He talks about the Society of Plastics case. Well, we've already talked about that. I will move on briefly, if I could, to the two other issues in the case. One is attorney's fees and claim splitting. we talk about this in the briefing. A claim for fees is not a separate cause of action. And that is why this court has held in the O'Connell and Wavertree case that if a plaintiff has a potential right to recover fees, the plaintiff must make his or her claim for fees and pursue the recovery of fees in the case in which those fees are incurred. And in this case, the plaintiff did not do that. He made a claim for fees in the federal case, but he did not pursue that.
Go ahead, Judge Shulman.
Go ahead. You're first.
Sir, wasn't the federal action dismissed without prejudice?
A portion of it was dismissed without prejudice, yes, Your Honor. But
Okay, which portion was that?
It was the portion having to do with access to the third floor of the, it was the state claims, the city claims having to do with the third floor access to the restaurant. The ADA claim was dismissed, I believe, with prejudice, Your Honor. But that doesn't.
So if the federal court dismisses without prejudice these state and city claims and declines to exercise supplemental or pendant jurisdiction, how could the plaintiff pursue any further his claims for attorney's fees on the city and state human rights law claims?
He did not have to voluntarily dismiss the federal claim in the first place. It was his voluntary dismissal of that federal claim which caused the door to the federal courts to be locked.
He stipulated,
he
stipulated to dismissal.
I'm sorry, yes.
Correct?
I'm sorry.
And there was no such argument about the attorney's fees argument made below, right?
The plaintiff did raise the attorney's fees argument in the court below. He did not raise the building code issue in the court below, but he did raise the attorney's fees issue. And
I'm saying the defendants did not raise this issue below.
The defendants did not raise the attorney's fees issue?
Yes. This argument that dismissal of the federal action and the state claims and as well as the attorney's fees that correlated to those claims were dismissed, and they stipulated to dismiss that with prejudice, but there was no mention about dismissing the city HRL claims.
You're talking about in the federal case?
Correct.
Oh,
which is what you're arguing, that they were, that basically he's out because those were already dismissed and stipulated to be out with prejudice.
You said below, and I thought you meant below in this case, but in the federal case, Your Honor, the state claims were pending at the time of the dismissal, yes, but the plaintiff did not have to dismiss his federal claim, which resulted in the dismissal of the state and city claims as well.
And these attorney's fees are actually a remedy, aren't they? Rather than a claim, they can't be asserted separately without the city HRL claim. You need one to be able to assert an attorney's fee claim, right?
Exactly correct, Your Honor.
Okay, so you can't have one without the other. It's not an independent claim in that it has to flow from the actual violation of the city human rights law action, correct?
It does, Your Honor. And the fact that he took the voluntary dismissal, which resulted,
but not of his city claims. You keep on pointing to the voluntary dismissal, but that was only as to the state claims, and the court specifically dismissed the city disability claims without prejudice to their reinstitution in the Supreme Court, which would logically flow that the remedy for that violation likewise flows.
I disagree with that, Your Honor.
And what in the stipulation contradicts what I've just stated?
The stipulation was to dismiss the federal claim. He did not have to take a dismissal of the federal claim. There was nothing that forced him to do that. That's what he asserts in his brief, that he was forced to dismiss the federal claim. He was not. He could have continued to pursue that federal claim in federal court And if he'd been successful, he could have recovered attorney's fees. And if he continued to pursue that federal claim, he could have also pursued his state claims as well. And it was the fact that he took the voluntary dismissal that resulted in the dismissal of his state claims. And I suggest
that prevents him from getting attorney's fees on the city claims. I don't understand the nexus.
It prevents him from claiming, in this case, the attorney's fees in the federal case. He can pursue a claim for attorney's fees in this case for the claims he raises in this case, but he can't pursue a claim for attorney's fees in this case for time he spent in the federal case. That's what I'm suggesting.
Got it. So you're limiting the restriction to just fees on the city, the prosecution of the city case, not on the dismissed federal action.
I am saying that he can pursue a claim for attorney's fees in this case for fees he incurs in this case. That is what I'm saying.
All right.
Let me talk.
Thank you.
We're
out of time.
I have a question. May I?
Go ahead, Judge. You just got a Hail Mary, Mr. Sampson.
Oh, I
Go
want
ahead,
to ask you questions in reference to the building code.
Yes.
You say that the building code provision, the building code says that disabled access need not be provided to floors that measure less than 250 square feet, and you indicate that
2,500 square feet.
Oh, thank you. And you indicate that the third floor has less than 2,500 square feet.
Yes,
so
right.
my question to you is this: the building code concerns reasonable minimum requirements and standards as to forms and methods of construction, and I refer directly to the building code and the purpose, the paragraph that defines the purpose of the building code. My question is, does the building code define what disability access has to be provided?
It does. It does provide, both the current code and the 1968 code provide what access has to be provided.
Does it, I'm sorry, does it indicate a minimum ceiling or more?
Well, relevant to this case, we're talking about a prior code building, which is governed in this case by the 1968 code. And what the 1968 code does is to provide an exemption from accessibility requirements for floors of a building having fewer than 2,500 square feet. So that's what it provides relevant to this case, Your Honor. Was I responsive?
Are you saying that the building code thus supersedes or outranks the city human rights law?
I'm not saying it outranks. I think the building code and the accessibility provisions of the human rights law are part of the same administrative code, and they have to be construed consistently with each other.
Do they serve the same purpose?
They serve, yeah, absolutely they do, Your Honor.
Well,
because
the building code, as Judge Gonzalez stated in her last question, is geared at codes for construction, whereas the city human rights law has a different focus, no?
Well, the section of the building code that we're talking about is the accessibility section of the building code, and its purpose is to provide access for persons with disabilities. And so I suggest to Your Honor that they have the same purpose.
All right, but what you're arguing is that essentially because the building is grandfathered into the 1968 code, that somehow that means that the application of the city human rights law is limited and restricted in its application by the building code. And would it not logically be maintained that it would be the opposite if public policy concerns are to prevail?
I think the public policy concerns are embedded both within the accessibility provisions of the building code as well as the human rights law. And I think they have to be construed consistently. The human rights law provides a broad provision requiring access.
Counsel, I'm going to interrupt you. So I'm going to piggyback also on my colleague's use of the term grandfather. So we know that if there's an extant condition that would not be in compliance with newer codes, newer legislation, oftentimes that condition or that whatever it is grandfathered in, and that person's not going to suffer any penalty, or that entity that it owns the building or maintains the building is not going to suffer any penalty. That's always possible. But here you have an elevator that's removed, an elevator that provided access to all 3 floors. So at the point where it's removed and a lift is instituted as its replacement, and that lift only goes to the 2nd floor, does that—
And only installed after litigation is enacted.
So going forward, does that lift then have to be in compliance with the broader scope of the human rights law, as opposed to what you're arguing is that narrower scope of the building code?
Well, let me try to break it down a little bit if I could. The elevator was moved back in the early 2000s, well before the current code came into effect. So it was removed before McDonald's moved into the building, like back in 2001 or 2000 is my understanding. The lift was installed by McDonald's in 2015, and that was before the current litigation, Your Honor. So the litigation did not motivate that lift between the 1st and 2nd floors to be installed. That was installed.
And you also never argued economic infeasibility as far as the potential remedy of having to restore the elevator or otherwise provide access in some way to the 3rd floor.
Well, I don't think we need to argue economic infeasibility, because there's simply an exemption applicable to floors having fewer than 2,500 square feet. As for the grandfathering argument, Your Honor, this wasn't, I guess you could say it was grandfathered, but you look at the current code to see how the current code treats prior code buildings. And there's a section that we cite in the brief concerning in the current code that talks about prior code buildings. It says certain alterations are subject to the current code. None of those alterations described in the current code apply to our building or apply to the 3rd floor of the McDonald's restaurant. And it's for that reason we have to go back to the prior code to see what it says with respect to the accessibility requirements.
Is there a bathroom on the 3rd floor?
Yes, there is.
Okay. All right.
And also the 2nd floor, Your Honor.
Yes, no, I know there was on the 2nd. I couldn't recall about the 3rd. Thank you so much. We're out of time.
Thank
All
you.
right. Counsel, you have 2 minutes on rebuttal.
Thank you, Your Honors. Quickly going to the question, Judge Gonzalez, you had before regarding the specificity of the complaint in terms of the plaintiff actually visiting. I'm not going to go through the details, but on pages 8 and 9 of plaintiff's reply brief, it identifies all the factual details that are contained in the pleadings regarding plaintiff's visits and attempting to access it. Another thing to keep in mind here is that this is a motion to dismiss. So this kind of a claim is not like fraud where there's particularity required in the pleadings. If there's an issue with regard to the amount of information that the defendants require, then they can move for a more definite statement. That's a lot less drastic than just, dismissing a case outright based upon a standard that should not be used in New York State court. So that's plaintiff's issue. With regard to the defendants talking about that, they make it seem as if plaintiff had this just out of nowhere dismissed his federal court complaint. That didn't happen at all. If you look at what's in the record itself, the judge directed the plaintiff to specifically tell the court if he was going to be keeping the ADA claim in light of the remedial measures taken by the defendant. So the plaintiff had an actual obligation to do it. According to defendant, plaintiff should have just kept his, what he believed at that time, non-viable ADA claim, just so that he could keep a claim for attorney's fees. That's just completely untenable, unreasonable to keep a claim that is no longer viable. And then the issue becomes too, that the plaintiff here told the court, actually, it's also in the record, told the court a month before it issued the dismissal order, it identified the claims that it wanted to keep and intended to pursue. And those claims included the state and city human rights laws, as well as the claim for attorney's fees. And that was identified in the letter to the court, informing it what he wanted to stay. Then a month later, the court, without any briefing from the parties, without any input from the parties, looks at the case and says, oh, the ADA claim, that my own federal claim is dismissed, I'm dismissing everything, and the rest you can go into state court because it's a dismissal without prejudice. That's how it actually happened. Thank you.
Thank you. We're out of time, counsel. We've got your papers.
Thank you.
McIntosh versus NYC DOE.
Good afternoon, Your Honors. May it please the court, Daniel Dugan for the appellant, Alice McIntosh. Ms. McIntosh commenced this action against her former employer, the Department of Education of the City of New York, based on discrimination due to race and age, leading to the termination of her probationary employment as a teacher. On the motion for summary judgment, Ms. McIntosh met her burden in opposing that motion, as the record evidence shows that the circumstances surrounding her termination and this give rise to an inference of discrimination based on race and age. And the cited basis.
Counsel, don't those claims have to be pleaded with great particularity, providing the actual statements made when, where, in front of whom? Isn't that required?
I'm sorry, what was the first part of your
question? For the age and race discrimination? I looked through the record, and other than making claims about white teachers getting more support and African-American teachers being put through more harassment or hassle, as she describes it, outside of those general, very conclusory statements, there are no specifics and no affidavits to back any of that up either.
Right, so under the mixed motive standard, if the defendant can show that at least one of the reasons set forth by the defendant for the termination.
How does she show even one of those reasons is my question. I see no particularity that is required here.
Well, the defendants stated that it was a performance issue that Ms. McIntosh was terminated for. Ms. McIntosh has clearly laid out that she was not receiving the required support, the mentoring. She entered into a mentoring agreement, which required a certain amount of hours of collaboration, supervision, coaching from a mentor. She did not receive that. She testified that she observed her comparator, a younger Caucasian teacher. She received that mentorship throughout the 2 years. So to base the termination on poor performance when there was disparate treatment between Ms. McIntosh and a similarly situated comparator, a teacher that came in at the same time as her, a new teacher, to base the termination on performance, then falls
Counsel,
under
again, I don't, again, other than conclusory statements, because I really, it strains credulity that she would be able to attest to being able to observe her white counterpart receiving additional support while she's supposed to be in a classroom. Okay, so that aside, how do we deal with the issue of her probationary status and the heightened standard for your client in light of that standard, in light of that her status as a probationary employee?
Well, she was a probationary employee, and as defendants assert, she could be terminated for no reason at all. They state a reason for her termination here. So now that is what the basis is. So if defendant can then show on the summary judgment motion, as I said, that if one of the reasons they're stating, and they cite poor performance here, the second year annual professional performance review, that's what they relied on to terminate her. They stated that reason at the time of her termination. If defendant on a motion for summary judgment can show that one of those reasons is false, misleading, it becomes a question for the jury.
Okay, so if we find that your client has not raised such an issue, then we're done.
If she raises,
If we disagree that we don't believe that any issue has been raised, that there is no support for a age or race-based discriminatory claim, that was just a pretext, that firing her for unsatisfactory conduct and teaching, right?
yes, Your Honor, you do have to find that one of the reasons was pretext, yes.
Okay, all right, we'll hear you on rebuttal.
Thank you, Your Honor.
Counsel, I want to make sure I don't butcher your name, so I'm just going to call you counsel.
Sure.
You may proceed.
Thank you, Justice. Good afternoon, and may it please the court. Kevin Osowski on behalf of the New York City Department of Education, the respondents here. After a full opportunity for discovery, Ms. McIntosh has still nothing more to support her claims of discrimination than her own conclusory assertions and flat denials of record evidence. Supreme Court properly granted summary judgment to the department, and this court should affirm. Regardless of which part of the McDonnell-Douglas framework this court considers, the admissible evidence adduced in discovery favors summary judgment to the department. First, Ms. McIntosh failed to meet her prima facie burden to show an inference of discrimination. In order to do that, she needed to adduce non-conclusory evidence that her termination occurred under circumstances that give rise to an inference of discrimination, and her own speculation isn't enough. She says that she was treated differently than other teachers, but again, as Justice Manzanet pointed out, it's solely based on her own word and her own assertions. She doesn't develop the comparators. She doesn't provide additional affidavits to back those kind of statements up. And she doesn't identify any derogatory statements or other comments sort of floating in the school environment that plaintiffs typically assert in these kind of cases that may create an inference of discrimination. Even if the court finds that she did plead or did meet her prima facie burden, the department has ample reasons that are well documented in the record to discontinue Ms. McIntosh. She had, by her own admission, she violated the school's policy for obtaining coverage in the incident where she failed to be on time for one of her classes. And I think viewed in the context of this school environment and the type of students who have extreme need for supervision and need to be monitored on a regular basis or on a constant basis, the tardiness that Ms. McIntosh exhibited and that she admits to is not something that should be swept aside as insignificant.
So, counsel, this is Judge Gonzalez. So we were aware that this was a school for severely emotionally disturbed students. We're aware of that, and we're aware of the fact that this was a special ed teacher who was a probationary employee. Your adversary says, and the plaintiff says, that under the mixed motive analysis, there was discrimination. Yes, she was offered mentoring opportunities, but they weren't the same as what was offered to her colleagues there. What do you have to say about that? Because we're aware of the record. We're aware of the many opportunities for mentoring that are listed by you. What do you say about the fact that she says, I have a comparator and we weren't treated the same?
Well, Your Honor, with respect to the comparators that Ms. McIntosh identifies, with respect to the other teacher that she claims that was receiving mentoring and she wasn't receiving mentoring, the only evidence that she's been able to adduce throughout the entire years of discovery here is her own statements to that effect. There's nothing else in the record that supports her assertions that she was treated differently than this other person. And she also hasn't proved up the fact that this person is an actual comparator. Even if she was not provided with mentoring, she hasn't demonstrated through discovery that the person that she's saying received the kind of mentoring is a comparator, that person is a probationary teacher, that person was under the same kind of circumstances that she was. And similarly, when she tries to draw comparisons to other African-American female teachers who she claims were treated unfairly, that is solely based on her own testimony, and the testimony itself is hearsay, so it would not be admissible. And the substance of what she's saying is that those teachers told her that they believe they were treated unfairly. And there's nothing else that she was able to deduce throughout the entire discovery here to shore up her claims.
All right, thank you so much. Mr.
Thank you, Your
Dugan,
Honors.
you have 1 minute.
Thank you. So in reference to the lack of mentorship, it's required by the collective bargaining agreement, the chancellor's regulations, and state law. And the record evidence does show that she didn't receive that required mentoring, the one-on-one, while defendants have included information in the record as to workshops and professional development. That's different than the actual required mentorship, which is one-on-one, a meeting. The log that was produced of this mentoring activity only reflects meetings at the beginning of the year. Ms. McIntosh testified that she never—
Counsel, the plaintiff alleges that the mentoring records were fabricated, doesn't she?
Yes, she does. So in the log itself, there lists different types of intervention mentoring that occurred. She indicated that those meetings or interventions never happened. The individual that the log reflects performed that mentoring wasn't at the school. It was at a different district location. That sometimes teachers met with her in a group, but that these individual mentoring occasions, and only the first year does the log reflect. There's no reflection of any mentoring in the second year. But she said they did not occur. This individual had never been to her class or met with her one-on-one. And again, this raises a question of fact as to whether the stated reason was pretextual.
Thank you. Thank you so much. We have your briefs and the record.
Thank you, Your Honor.
Okay. Torres versus Bogota Service Corp. Doing business as Food Bazaar Supermarkets. Counsel,
Good
you may
afternoon, Your
proceed.
Honors. Michael Rasciuto on behalf of the appellant Norema Torres. Your Honors, this case
Wait, I'm sorry. Hold on one moment. I think I've skipped over a case. What I'm going to do is, since I have you ready to go, with my apologies to counsel on Sterling Bank, I will call you next. This is what happens when you have a stack of papers and you grab two at a time. So my apologies to Sterling. I promise you're up next. You may proceed, counsel.
Okay.
Out of turn. Go ahead.
Good afternoon, Your Honors. May it please the court. Michael Rasciuto on behalf of the appellant Norema Torres. Your Honors, this case is about applying the long-held summary judgment standard to the particular facts of this case. This case involves a slip and fall on a white starchy substance on the white tile floor of the respondent's grocery store. The respondents would like this court to hold that the burden is on the plaintiff in opposition to summary judgment to establish that the defendants had constructive notice. However, this court has long held that the burden is the other way around. In order to establish prima facie entitlement to summary judgment, the defendants—
I have a question.
Yes, Your Honor.
Burden shifts only if the defendants prevail on the prima facie, that they're entitled to summary judgment. So assume that they did meet their prima facie. Did you have enough in your opposition to raise a tribal issue of fact on the issue of notice? Because in her deposition, I looked at her deposition, and I don't think the video was in the record here because I went looking for it. But the deposition seems to indicate that they were asking, because she went back from the checkout counter back to the aisle to get the brownie mix, and then came back and slipped as she was coming back to the cash register aisle. But in the meantime, when that was happening, this all happened within like 20 seconds of each other. Two other people also traversed the same area that she traversed. So the question then becomes is that, you know, assuming that that there was a starchy substance on the floor there, just based on the time frame alone, it seems like that there wasn't enough time for anybody to know, or even for the defendant to even clean it up. I mean, if it happened, so how do you say that? How do you argue that you can raise that factor issue based on based on that kind of evidence that's in front of us?
Well, you're correct, Your Honor. The video is not before this court as the record.
But it's nice to have it.
The testimony.
Like
Yes, Your Honor. The moving defendant did not submit it as part of their motion, and if they did, maybe things would be different. The video.
But you have a copy of the video, don't you?
Your Honor, I have seen the video, and I could submit to this court that the individuals that are seen walking into that aisle do not step in the exact area where the plaintiff steps where she falls.
Okay, but to bounce off of my colleague's point, if you have the video and you are going to attempt to assert that somehow that video would have been helpful, then you certainly had the opportunity to submit it yourself.
Well, so there were snapshots from the video that were submitted and are made part of this record on appeal. I believe that those snapshots create a question of fact as to liability. Your Honor.
So you're saying that only the two steps where where your client stepped on the way back to the checkout counter were the only steps that were slippery, because wherever her foot landed on the way to the checkout, back to the aisle to get the brownie mix, she doesn't step on those two steps, and neither do the other two people, right? So you're saying that there were two steps, two places on the floor where her foot could land on that would cause her to slip?
Correct.
And that is sufficient to constitute constructive notice?
Well, Your Honors, the fact of this case is that the condition was a white starchy substance on a white tile floor,
which no one else seems to identify except your client.
My client identified it, and the EMS, I identified.
They didn't identify it.
Well, Your Honor, if you look at the snapshots that were submitted, in
opposition, we would have been better off submitting the video. The snapshots don't tell us much. I mean, especially given the fact that the plaintiff had an opportunity at her EVT to view the video with defense counsel asking her questions about the video frame by frame. I mean, that was extremely helpful, at least in my mind. But they make the argument saying, when you're arguing about the video, you had the video too.
Well, but the burden is not on the plaintiff in opposition to summary.
I'm not saying no. It's your burden is to raise a factual issue. You have that burden, right? You're not arguing you don't have any burden at all. Your only burden is to raise. It's a simple burden. It's a very low threshold. All you got to do is raise one single factual issue. Assuming that they established prima facie their entitlement, you have a burden. You can't say you have no burden. You have a simple burden, very low threshold of raising a factual issue, and point to somewhere in the record. Help me out. Point me somewhere in the record where you say, "Oh, that's it, right there's the factual issue."
Well, Your Honor,
I'm going to give you an opportunity to find the answer to that question, and in the meantime, I'm going to hear from defense counsel with her opposition, and then we will hear you again. Okay, counsel.
Good afternoon, Lisa Gokul-Singh for Bogota. I was actually going to just submit and rest on my brief, but since we're giving counsel time to find an issue of fact, I will. I just want to point out that Berger versus ISK is one of my favorite decisions out of this court. But since Berger versus ISK, this court has taken somewhat of a holistic view of evidence in moving for summary judgment. So a defendant may demonstrate prima facie entitlement to summary judgment based entirely on the plaintiff's deposition testimony. In this case, her testimonial evidence was that she did not know for how long the condition existed and that it was not visible and apparent. She didn't see it at any time before her accident, even though, as the court points out, she traversed that very area seconds before her accident. She never saw it before or after. This court has inferred, or courts have inferred, constructive notice when the condition is dirty or messy, or there are footprints, or there are broken jars or crushed fruit. But in this case, the plaintiff, who's the only witness as to this condition, she testified that the condition was starchy white, a pristine white, despite the fact that this was a busy Thanksgiving weekend before Thanksgiving supermarket day.
The photographs taken from the video have timestamps on them.
They do.
So the amount of time from which the plaintiff left the cash register to retrieve a different brownie box and returned and fell. How many minutes or seconds was that?
It was less than 20. I don't have the
Less than
exact.
20 seconds or minutes?
Less than 20 seconds. It was very, very quick. It was very quick.
And
she was, you know, I don't mean that she was in a rush, like she was running and that's why she fell. I don't mean that. She was being polite to the cashier who was, you know, obviously waiting for her. And so she didn't delay or tarry in the aisle. She went, she got the correct brownie mix and she came back and she slipped and fell. It is unfortunate, but there was no notice here. My client, as you can see from their handbook, they take great pride in trying to prevent these types of accidents. They have procedures set in place. I know counsel argued on the appeal for the first time about recurrent condition. Not only was it not pled, but this court's decision in the Harrison case, Harrison versus New York City Transit Authority, shows that as long as we have some means by which to deal with, you know, recurrent conditions, that is all that's required to demonstrate prima facie that we don't have constructive notice.
Thank you so much.
Thank you.
All right, you have 1 minute on rebuttal, and now you can give us the answer to Judge Oing's question. Unmute so we can hear you.
Thank you, Your Honors. The area where plaintiff slipped and fell was not stepped on in any of the video that we have seen. Now, there is a boy in blue who can be seen, and there's snapshots of him sliding and slipping prior to the plaintiff in another area similar to
That's not the same area. That's not the same area, counsel. He was
but
skating
Your
somewhere
Honors,
else.
but Your Honors, the color of this condition makes this case particular. I'm worried about a slippery slope here, and that slippery
that's a kid who's horsing around in a supermarket. And if it were a seriously slippery condition, him horsing around like that, he would have fallen to the floor.
Your Honors, I worry that the exception would swallow the rule here if this court is to find that you know, there's no question of fact as to whether or not there was a condition here. The jury should be allowed to consider that. Simply because the condition blended in with the color of the floor, then we're allowing any defendant to get out simply because the condition is actually more dangerous than a regular condition, which is visible and apparent. The visible and apparent standard that this court has held in Gufrida versus Metro North takes into account the location. This occurred near the cash registers in a very high trafficked area, like the respondents concede on a Saturday before Thanksgiving. They had a process and procedure in place to inspect the aisle where this occurred, because it's an area where spills occur. They concede that starchy white substances spilled on their floor and made the floors more slippery. Yet there's no evidence that they conducted any inspections at all.
That's not true. That's not true. The store owner went over and checked the shelves to see if there were any products that were open, which sometimes happens, and he found none. Anyway, we have the record and we have your briefs. Thank you both so much.
Thank you.
We're out of time. Sterling National Bank versus Friedman. I believe that. There we go. Okay. Mr. Cole, you have 5 minutes.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Adam Cole, and I represent Petitioner Appellant Sterling. This appeal really presents two issues of law. The first issue of law is what level of interest must the person possess in order to invoke the priority procedure under Section 5239 of the CPLR. The section refers to any interested person, does not refer to lien holders, does not refer to owners, not even refer to creditors. It talks about any interested person. And we know that not only because on the face of the statute, but also because the Court of Appeals has said it. It said that this statute is broad. It allows for any interested person in Cruz. And just a few weeks ago in Plymouth Venture, the court reiterated that in the context of Article 52, the Article 52 remedies, especially those that talk about any interested person, is broad and allows any interested person to challenge competing interests in a particular piece of property.
So this is Judge Owen. I have a question. I mean, maybe I read the wrong record, but I thought that your argument was that you want to be able to grab the real estate, the real properties, and hold them as your own and sell them and recover them. And the Supreme Court said, no, you have an interest in the membership. You have an interest in the judgment debtor's membership of the LLC, but that doesn't translate having exclusive interest or realization of the real properties in that LLC, right?
That's correct.
Let's get right to the heart of this. You just want the properties. You just want the real properties so that you can sell them and cash in on them. And the Supreme Court said, no, you can't do that.
Well, that's not entirely true. The procedure that we were using under 5239 is not to capture the real properties. If we already received turnover order of the LLC interests, and whatever that right is afterwards is a right. What we were trying to do, but the procedure that we are implementing in this case, in this particular part of the case, is to determine whether or not there were other entities that have an interest in the underlying real property. That is what 5239 entitles. The question is whether or not Sterling is able to challenge other interested parties to that underlying property.
Right, and Citibank is one of them. And Citibank's one of them, saying that we have an interest on the property.
Correct. And so once we're within 5239 as an interested party, not a lien holder, but as an entity that has an interest, then we have the right to then challenge Citibank's interest in the same property.
Yeah, but Mr. Cole, excuse me, this is Judge Shulman. But as I understand in the record, pursuant to a judgment of the federal court, Citibank was entitled to attach the real property. So they are actual lien holders of the real property that is part of the assets of the LLC, whereas Sterling has a lien on the Sterling collateral, which does not include the real property. So while you Sterling, right. So while you have an interest and while you have the ability to maybe orchestrate the voting, management, and sale of the real property as members of the LLC, you have to wait your turn until Citibank, as the lien holder, gets refunded its I guess monies, and then you get the rest as a dividend.
It's not.
Did I misunderstand their position?
Yeah,
and
it's not entirely correct for two reasons. First, Citibank's lien is based upon an attachment of Friedman's interest. It was not that Citibank did not have a judgment against the LLC. In fact, at the time, Citibank didn't have a judgment against Friedman. What 5239 entitles us to do is to challenge Citibank's lien. That's why 5239 empowers the court to turn around and invalidate the lien. It has it's right in the statute. It specifically says it can invalidate the levy as one of the remedies it can apply when Sterling is challenging Citibank's lien. So the question for the court is whether or not Sterling has the ability to challenge Citibank's attachment of the underlying property. We say we have the ability and the power to do that under 5239 because we're an interested party. Everybody agrees we're an interested party because our interest, our economic interest, is directly related and directly governed by whether or not another interest is being asserted in the underlying real property.
And don't you have the ability, I'm sorry, don't you have the ability in the alter ego action? I characterize that, forgive me, to do exactly what you need to do to challenge that attachment so that if they don't win, you will then be able to have your interests realized. It's not like you're deprived. You were allowed to intervene. You were allowed to do whatever you need to do to show how each of those LLCs with their individual real properties that are linked to each name, that's in one of the big footnotes that are throughout this record, are, as you argued, properly formed, all appropriate, all the arguments you're making to show, but you have that right, but doesn't change at this point where you don't get to say, okay, I want the real property now.
Well, let me respond on two grounds. First, I'm not entirely sure after the recent decision in Plymouth Venture whether or not the so-called alter ego plenary action is even valid, because what's being sought in that alter ego action is a determination as to whether or not the underlying property was properly garnished under 5201. It's a 5201 issue. And so under Plymouth Venture Partners, the court held, in another context granted, but it held that when you're within Article 52, the remedy falls within Article 52. That same issue, that Article 52 issue, was what was raised in the petition. I get it, Justice Shulman, I get it. I get that a year after the fact, or more than a year after the fact, after Citibank filed an action in bankruptcy court and was told and it was abstained because of forum shopping, Citibank then filed a new plenary action in the state court. So a year after the fact, we're ready to go. We've litigated, we've raised the issue. Citibank's noticed up on the issue. We're getting ready to conduct discovery and engage in summary judgment. Citibank starts a new lawsuit. And so what you're basically saying is, assuming that Citibank could do that and not violate Article 52, what you're saying is, in our case, which came first and it was teed up and was ready to go, that Citibank can come in and just file a brand new lawsuit to avoid summary judgment that was about to happen in the case that we filed. Citibank's
All right,
obligation.
you'll have time on rebuttal. We're out of time. Counsel, you may proceed.
Thank you, Judge. John Trevan Roy here for Respondent Citibank. The appeal by Sterling really is an odd appeal because Sterling's petition only sought two forms of relief, and Sterling received the two forms of relief sought in the petition, both in the opening and in the wherefore clause at the end. Citibank, in fact, consented right up front to the turnover. The parties agreed on the record in the lower court that certainly it would be better for Sterling, if it was willing, to manage these properties and these companies rather than of Jenny Friedman at that point. That consent happened immediately. The parties stipulated as part of that consent that Citibank was reserving its right to contest the request for a determination that Sterling had priority as to the Sterling collateral, which is personality only. I think that is now undisputed. Justice Maisley has admitted on the record that she lost track of that stipulation and entered an order in error granting the whole petition and adopting the language that Sterling put in its request for relief. Indeed, after doing its due diligence, Citibank concluded that Sterling did have priority as to Gene Friedman's personality. And Citibank thereafter, after the due diligence, consented to that relief as well. There was therefore no need for a summary judgment motion. Citibank wrote letters to the court that are in the record, filed papers advising that due diligence had been done, and Citibank now consents to all of the relief requested by the petition. The game here was, and in our view, frankly, the game was to capitalize on on the lower court's initial error, what the lower court itself described as a mistake in the first order, where the lower court lost track of the fact that the sterling collateral consisted only of personalty and not real property. In fact, no lien on real property, most rights as to real property can't be granted in any event by way of a security agreement and UCC filing. There was certainly nothing recorded. Citibank did not commence an alter ego action just as Sterling was about to get summary judgment. The summary judgment motion sought relief well beyond the relief requested by the petition and differing significantly in nature. In its motion for summary judgment, for the first time, Sterling says, well, we also want an order voiding Citibank's attachment lien. Citibank itself had been pursuing an order declaring effective, or quite possibly, if Citibank loses, ineffective and thus voiding its attachment since 2017. Citibank levied, pursuant to the bankruptcy court's order of attachment, Citibank levied first on what we're calling the shares, although they are largely membership interests in LLCs. There are a few corporations at issue. Citibank levied on those shares, or the U.S. Marshal on behalf of Citibank levied on those shares in late 2016. 15. In the spring of 2016, a few months thereafter, the U.S. Marshal recorded those attachments as to each piece of real property at issue. Citibank thereafter sought a bankruptcy court order declaring those levies to be effective on the basis that the real estate owning companies are all Friedman's alter egos. The bankruptcy court said, and that was part of a larger motion to determine that some offshore trusts were Mr. Friedman's alter egos, the offshore trusts still holding the shares. Judge Craig of the bankruptcy court ruled that yes, those offshore trusts are alter egos, and therefore the transfers of the shares to those offshore trusts are not invalid, they are transfers, but they may be disregarded for purposes of levy, and your levy on those shares is valid. Lo and behold, Sterling has a senior interest in those shares, so it didn't do us a whole lot of good. She further ruled that she would not grant our motion to determine that the real estate entities were Mr. Friedman's alter egos, making our levies on the real property valid, because they were not parties. They had not been joined in that bankruptcy court adversary proceeding. We made that motion largely because the evidence of the offshore trust alter ego coincidentally also established, in our view, that the real estate entities were alter egos of Mr. Friedman. In any event, we, pursuant to her Honor's suggestion in the bankruptcy court order, we commenced a plenary action naming those entities. We consented to Sterling's intervention because Sterling is indeed economically impacted by the ruling and has the right to intervene as so long as the Friedman entities did not step up and defend properly. The bankruptcy court thereafter decided, based on Sterling's motion, that although the bankruptcy court did have jurisdiction to decide this, it would indeed abstain in favor of the state court. It was a discretionary abstention, the decision's in the record, because the matter was no longer sufficiently related to the bankruptcy case of a couple of dozen medallion owning entities. Those medallions had been liquidated, the creditors would not be impacted by this decision, and she, on a discretionary basis, abstained in favor of the parties dealing with this in state court. Citibank, 6 weeks
All
or
right,
less thereafter.
Counsel, we've gone on way past the 5 minutes.
Excuse me,
So
Judge.
to my colleagues, are there any other specific questions? Okay, we have your briefs and the record. I will now hear counsel on rebuttal. You have a minute, sir.
Thank you, Your Honor. I'd like to just address the issue of what was requested in the petition. There is a question as to what constitutes the sterling collateral. And the reason for that is the petition specifically requests at page 62 of the record that sterling is entitled to a determination by the court that its rights in the sterling collateral are superior to competing rights of other parties. Sterling collateral is a definitional term used in the petition, and it includes not only the rights in the LLC, but the rights that were declared in the sterling security interest, which is all right, title, and interest in those LLCs, which under this court's decision in Glicklad includes economic interests in the underlying LLCs, which are the properties. So when Sterling filed its petition, it specifically requested as to those underlying properties to make a determination as to which interest is greater. And as part of that procedure and as part of that request, 5239 entitles Sterling to request to challenge a competing interest. That's what 5239 is all about. It's not
Okay,
just.
thank you, counsel.
Thank you, Your Honor.
All right. Lipinski versus Extel Development et al.
Good afternoon, Your Honors. May it please the court, Michael Cassell for the plaintiff appellant Ronald Lipinski. In this matter, the lower court dismissed on summary judgment the entirety of Mr. Lipinski's complaint. Specifically, it dismissed his Labor Law 241-6 claim, which was predicated upon Industrial Code 1.7D, and the Common Law, Labor Law Section 200, Common Law negligence claim. As we set forth in detail in our briefs and analysis of this court's law, especially recent case law, such as the Potenza decision, demonstrates unequivocally that Mr. Lipinski was entitled to summary judgment. At a minimum, the court should not have dismissed his claims, and therefore, at a minimum, this court should reinstate the 241-6 and the 200 claim. More specifically, there's really three relatively recent decisions by this court, all of which I submit are relevant. We have the Potenza decision, which, as we cite in our briefs, set forth four key facts. At the time of the accident, the plaintiff was located between the guard booth and the worksite entrance. It was just one or two entrances used by the workers to access the worksite. The area where the accident occurred was generally used by workers to access the worksite, and the area should have been kept clear of snow and ice. This court held in Potenza that under those circumstances, the plaintiff was entitled to summary judgment, that the accident occurred on a walkway under 1.7D, and therefore was covered by 241-6. The facts in this case are highly analogous. We have the plaintiff testifying that he was just inside the gate, the work gate. His coworker parked in a designated parking area for the workers. He was just inside the gate. The accident reports show that the accident occurred just by the gates to the entrance to the work site. Plaintiff, as far as the second factor, plaintiff testified that Tishman directed that the workers use the specific path that he was taking. He said it was the only route he could possibly take to go from the gate to the trailer. This was undisputed. Also, it was the walkway that the workers generally used to access the work site. This was uncontroverted by the plaintiff, and it clearly should have been kept clear of snow and ice. In fact, at 1505 of the record, we cited the defendants.
Does it have to be a formal walkway? Because when you use that term, I'm thinking a sidewalk. It doesn't have to be a literal sidewalk or concrete or asphalt path. It just simply has to be a pathway going back and forth, a form of egress into the shanty. No?
Yes, you're exactly right, Your Honor. The condition of what the ground made of is completely irrelevant. The statute requires the employer or the GC and the owner, not the employer, sorry, GC and owner, to provide safe footing. So when you have a worker who is parked in a designated area and then has to access the work site, the GC and the owner must provide safe footing, must provide a clear path. In fact, the court in the Venezia case, VENEZIA, addressed this exact issue. And understand we found a question of fact there because the defendant put forth evidence that they had cleared a path. There was a path for the workers to walk through. They cleared the snow and ice. In contrast here, there's zero evidence. It's uncontroverted that Mr. Tolk had to get from the gate to the trailer and nothing was provided to help him get that way.
So
there was nothing.
Counsel, if I may, so I don't know if you're familiar with the term herd path, but if you're using the term walkway, but if the path was created by the workers, in other words, just as the way deer would use a path and create a herd path in and out of the woods, if the path is created by the workers because there is no sidewalk, there is no roadway, there is no helicopter to bring them from the gate to the work shanties, then does that make a difference? Does that take away from the obligation of the owner or even the W5, which contracted to salt and to do snow removal of sidewalks, roadways, hoist platforms, and means of egress as required? Does that change anything if the walkway is simply created because people use their feet to get through the snow because nothing has been cleared?
It would not. I mean, let me explain a little bit. If there was a path provided and the workers decided, or a clear footing between the workers' route that they had to take to go from the parking lot to the work site. If there was a clear route provided and the worker decided not to use that clear route, then yes, then the worker would not be entitled to summary judgment. But a clear route must be provided for the workers to go to the work site, to get to the building, from the parking lot to the gate to the building. That was not provided here. It was uncontroverted that Mr. Lipinski was
Counsel,
taking...
you're running out of time on your direct argument. Are there other issues you want to hit before we go to the next attorney?
Just on the 200 claim, I mean, we set forth in our briefs as to why Mr. Lipinski was entitled to 200. And as far as the court dismissing the 200 claim at a minimum, the burden was on defendants to show that to sustain their burden, they didn't put forth anything as to their burden. And therefore, I asked the court to reverse the lower court's decision. Thank you.
Okay. All right. Counsel for W5.
Yes, may it please the court, Alan Russo on behalf of W5 Group, where we are the third party defendant in this case, and we're actually both an appellant and respondent.
Yes.
I'll address the issue of our appellate issues first. We're a third party defendant. We were retained by Tishman Extel to provide certain services on the site. And our duty, the scope of our duty, is governed by that agreement. Okay? We owe no legal duty to the plaintiff. Our only legal obligation is to Tishman. Under the circumstances of this case, there was a question raised as to whether or not this slip and fall occurred on a sidewalk, on a pathway, on an elevated platform, on a hoist run. Those were the areas, or roadway, those were the areas that were designated that we were required to perform snow and ice removal.
Didn't the language also refer to a manner of egress?
I'm not exactly sure what a manner of egress is.
It's a path that doesn't have a official walkway, for instance.
That's correct. There was no official, but where the plaintiff entered was not an official walkway. In fact, there was another entryway into the site, the area where this happened.
Counsel, I'm asking a question.
Okay,
what official walkway was there, and what did your client do to clear that walkway?
There was no official walkway in the area where plaintiff fell. It was a football field side courtyard that housed the shanties where the workers would come.
And so what path and I don't care what we call it, what path, what safe path, what cleared path was provided for these workers from that entry gate to the shanty trailers where they had to begin their workday each day?
There was no requirement in our contract to do any snow removal in that area. In fact, Mr.
Counsel, if I
So is
may.
the the answer to my question is there was no walkway? There was no clearing of any path for these workers to traverse that football field courtyard? Is that your
correct.
answer?
Yes.
Okay. Judge Gonzalez, I believe you had a question.
Yes, I'm going to the scope of work again at record at 494, where it says the W5 would do snow removal of sidewalks, roadway, hoist platforms, hoist runs, and any other means of egress within 4 hours of the storm ending. And then it goes on to say salting as well. So is it your position that we don't know whether the pathway, herd path, means of egress created by the workers to get from the gate to the trade shanties, is it your position that that is a question of fact that needs to be determined whether or not this was an actual pathway, or are you saying that it wasn't up to you? Tishman had to tell you what to do and that was the end of it?
Well, essentially both of those. Number one, it was not a pathway. It was what they called the shantytown area. There was no pathway designated. And the witness, who was the assistant superintendent of Tishman on this project, testified at deposition when pressed that, yes, we did, meaning W5 Group, did snow removal on the site. However, he could not say whether or not the area, the site means where the building's being done, the area where the shanties were located was part of that site. In fact, he was pressed on the issue and said, I don't know, I don't believe they were. However, if we asked them to do snow removal, they would do it. We didn't come on to the project till 7 a.m. This accident happened at 6:30 a.m. We put forward.
But it had snowed the day before. So what remedial action was taken to ameliorate the snow condition the day before?
We were not required to remove snow in that area. We have an affidavit from our clients.
So I'm just trying to understand whether all of the owner, the contractor, the subs here, were these workers supposed to levitate from the entrance over the snowy open area to get to the shanty? How were they supposed to safely get there? And what path was provided for them to do so?
There was another entrance to the project, which was the primary entrance to the project.
So now are you saying, because is that argued anywhere, that somehow the plaintiff was wrong in using the entrance he used, and if my memory serves me correctly, a Tishman employee opens up that gate every day. So if that gate should not have been used, then it should have remained closed.
Most respectfully, I don't represent Tishman. I'll yield to Tishman's counsel to speak as to what their obligations may have been on the site. I can only speak to my client's obligations. My client specifically testified, we have an affidavit from him, that they would do snow removal if they were asked to do it, and it was beyond the scope of the contract. They would actually invoice Tishman for the additional work. They searched their records. They were never requested by Tishman to do any snow removal in that area. And Tishman has not presented any evidence to the contrary. There were no work
We'll have
orders.
2 minutes on rebuttal. Okay?
Okay.
Counsel for Extel, you have 6 minutes.
Good afternoon, Your Honors. My name is Gerard Rath from Shalvamity, Citron, and Spratt. I am appellate counsel to Mellapero, Prisco, and Klauber, the attorneys for the defendants' respondents. First off, this case really isn't like Potenzo. It looks like Potenzo on its face, but it really is not, because in Potenzo, there was a multiple evidence of a path being used. Here, there's no evidence of a path, and the plaintiff could have taken
Tishman's witness in the EBT described it as a manner of egress.
I agree, it's a manner of egress. The area where he entered 15 feet from the entrance was a means of egress, but that was 50 feet from his shanty. And so he could have taken other directions to go there.
Counsel, so I'm going to ask you the same question because it seems to me that you gentlemen are trying to pass the onus on workers to provide their own safety. So if the people on the ground who are supposed to supervise and ensure the safety of workers think, there's no way of clearing that field very easily, especially now that we've let it iced over from 3 days of snow. So maybe we shouldn't keep open that entrance so that our workers are closer to their shanty towns and don't risk falling. Why is that not a problem that would prevent summary judgment on this issue?
Well, the issue here is whether or not 1.7D applies, and it applies to walkways and passageways. And our argument is that it's not a walkway or passageway because it wasn't a defined walkway like the case law holds. And like you found—
But it doesn't have to be a defined. I've been on cases where a construction worker falls in a muddy patch between the building and, again, a shanty or a trailer, and we've held that has to be kept clear if it's a path.
Right, because it's a pathway, because it's regularly traversed.
The plaintiff says he had to take that pathway, so why is that not an issue of fact, sir?
Well, I concede that it could be an issue of fact, but okay. He could have taken multiple avenues to get to the shanty. As far as the Labor Law 200 claim, we didn't have.
So counsel, I can't resist multiple ways of getting to the trade shanty where he had to go. Like what? If there's snow, and it's been there for several days and it hasn't been cleared, but for the feet of the workers who were traversing one area to the other, what are the alternate ways if that gate was open?
Well, that defines the pathway. If he could go in other cases like Zukowski, it was a pathway between two piles of snow. So there was a defined pathway, a defined walkway. Here, there was no defined walkway because he could have gone multiple directions. And that's
like
what we mentioned in our brief.
Like how?
Just
I don't see it. I don't see
different directions.
Like how?
Look,
you mean instead of staying on the pathway where everybody's traversing, all the workers are going, he could have gone to the left, to the right, and so on and so forth. And therefore widened the pathway? Or
correct.
Created more pathways?
Right, and that's because there was no defined pathway here. Because
so everybody for themselves, as my colleague was saying, you put the safety considerations on the backs of the workers?
Well, the statutes, the regulation 1.7D provides that it has to be a walkway or passageway. And
the labor law provides that you have to provide a safe workplace.
Correct.
Let's start with that, right? And okay. How opening a gate that places a worker 50 feet away from the shanty that he has to go to in order to check in for work each day, and opening that, knowing the condition in front of them, I don't see how that doesn't create an issue of fact on negligence and on 241-6.
There could be an issue of fact as to that situation, but our position is that it's not a walkway, and our position is that in order to be responsible for Labor Law 200, we would have had notice of this specific condition. And there's nothing in the record that demonstrates that the owner said.
Counsel, you have a football field, according to your own statements, a football field full of snow and ice that has not been cleared after 3 days of snow. I don't think you can escape notice, but that's just me. All right, we have your arguments and your brief, and we will again look at them. Mr. Cassell, you have 2 minutes.
Just very briefly, defendant's argument that there was supposedly multiple ways for Mr. Lipinski to get to the work site would turn the label completely on its head. I mean, just because Mr. Lipinski could have gone this way or that way, first he testified and it was undisputed. It was the only route. Was there any other route you could have taken to go to your shanty besides the one that you took? Answer no. In addition, there was 0 routes, none provided that provided safe footing. So just because Mr. Lipinski arguably could have walked this way or that way, when there's no route provided to workers that provided safe footing, unless the workers could levitate, as Your Honor mentioned, the labor law is violated. Thank you.
Thank you. Okay, and counsel, you have 2 minutes.
Okay, thank you very much, Judge. Just very quickly, the third-party plaintiff witness admitted in their contract, there's no specific designation of snow and ice removal in the area where this accident happened. He admitted that. He also said he could have requested it, and my client would have done whatever they told us to do. They never told us to remove snow and ice at that location. There's no evidence of it. We produced a witness that said there's no proof of any invoicing to Tishman for that work. They would have invoiced him if they did the work.
Counsel, I got a quick question.
Yes.
I don't mean to interrupt it, but I know you're running out of time. The anti-subrogation argument you
Yes,
raised
I was gonna
with
get to
respect to
that.
third party, that
Yeah.
doesn't, does that apply to common law indemnification and contribution?
It wouldn't necessarily apply, let me see, anti-subrogation, common law. Well,
No.
yes, you can't bring a third-party action if you're insured by the same insurance.
No. Forget insurance. No insurance at all. Common law indemnification has no insurance tied into it. So I don't think anti-subrogation applies to that, to a common law claim.
No, it does under the contractual indemnity claim, which is what they're making.
You're not,
Yeah.
I'm not disagreeing with you. I'm just saying anti-subrogation doesn't, the
Wouldn't
theory
apply
or
to
that
common law
concept,
indemnity principles, yes.
it doesn't apply to common law indemnity principle. I mean, the only way you can avoid common law indemnity is you can show that the indemnitor or indemnity is liable, did committed some negligence.
Well, we didn't control the work site.
Right.
So
I
this is
know
not a
that.
vicarious common law liability situation.
Right, exactly, right. Although, right, I just want to make sure that
Okay.
the anti-subrogation doesn't cover common law indemnification.
You're correct, and that was
Thank
the
you.
last point I was going to make, that we also have the defense of anti-subrogation. And the proof in the record is that we enrolled in the OSIP, which controlled the site, and we were covered. So there's no basis for a third-party action. Their argument that they canceled our workers' comp policy before the time of the accident is not dispositive on the GL policy. And it's even specific in their cancellation. They cite the endorsement, which is only the workers' comp endorsement. So there's no proof that the GL policy was not in effect. And when you enroll in these policies, that's part of the economics of the way they do business. They paid for that.
All right, thank you. Thank you
Thank
all.
you very much. Appreciate your time.
Thank you. Okay. Matter of U.S. Bank National Association.
May it please the court, Sandeep Savla for Appellant PIMCO. Our submission is that both the language of the contract, which is the indenture, and commercial sense support PIMCO's interpretation that sale proceeds must be paid on
This has less to do with commercial sense and what the agreements say, correct?
Well, it's the agreements, but it's also if the respondent's position were to be followed, it would result in illogical consequences. And I can explain the illogical consequences.
Well, you've got 4 minutes. You decide how you want to use your argument.
Okay, well, I'll explain the illogical consequences first and then go back to the contractual language. But under section 12.1A1 and 5, and under 10.8D of the indenture, they say that the trustee can retain sale proceeds during the reinvestment period if the issuer wants to reinvest securities. There is no provision whatsoever that speaks to retaining sale proceeds in the collection accounts after the reinvestment period. But if respondents' argument is followed to its conclusion, it results in illogical consequences. Because the thrust of their argument would be—
Except the issue here is not where it's held, it's when it's distributed, no?
It is when it's distributed, correct.
I mean, that's the bottom line. The bottom line issue is that what does the language of the agreements dictate that the distribution has to be for the sale of these proceeds?
Correct.
Okay.
As I was saying, if the trustee can't retain sale proceeds during the reinvestment period, if there isn't going to be a reinvestment, it cannot retain sale proceeds. And it has to distribute on the next distribution date. But according to respondents, after the reinvestment period, the trustee must hold on to the sale proceeds no matter what. So you have a situation before the reinvestment period where they can't hold on to sale proceeds. After the reinvestment period, they must hold on to sale proceeds.
I thought
So
I must have read the wrong brief too. I thought the argument on the other side was more focused on for how long and when the distribution had to be made based on the particular agreement again, and the specifics here, the language of the agreement requires a quarterly payment. Is that not so? And if not, why not?
That is the argument that they are making.
But I'm saying the agreement seems to support that argument. So why am I reading the language of the contract wrong then? Why is this not quarterly?
The agreement doesn't actually support that language because in section 10.2G, it requires the trustee to transfer money for payment prior to each distribution date. Under section 11.1A, that provision states that notwithstanding any other provision in the indenture, on each distribution date, the trustee shall distribute amounts that are sale proceeds pursuant to section 10.2G. And the trustee, the entity that's responsible for the distributions, highlighted in its petition in paragraph 23 that this notwithstanding language, and said that, you know, section 11.1A is clear that it's notwithstanding any other provision. Now, section 12.1, which the respondent
but wouldn't that reading eliminate the definition of what the term due period is?
It would not eliminate the definition of due period, because the way the due period works is you look first at whether the next distribution date is monthly or quarterly, and then you go back.
And here it's quarterly, correct?
No, here the next distribution period after the sale. So the sale took place in January of 2021. The next distribution period would have been in February of 2021, which was a monthly distribution date. So what respondent is saying is, rather than distributing it in February, you trustee hang on to these sale proceeds for 2 more months and then distribute the proceeds in April.
Sir, what meaning, under your interpretation of the various relevant provisions, what meaning and effect then does section 12.1A5 have?
Right.
So 12.1A5 refers to the reinvestment period and retention during the reinvestment period. That's a period of time in which—
No, wait a minute. That provision clearly states that the sale proceeds of any CDS will be deposited in the appropriate collection account and applied on a quarterly distribution date.
Well, that's 12.1A, not 12.1A5. But 12.1A, that provision you're referring to, that does refer to a quarterly distribution date, but it also refers to 10.2A and C, which is a collection account provision which triggers 10.2G, which requires distribution on the next distribution date, which is a monthly distribution date.
Okay, all right, we'll hear from the another question? No, okay, I'll hear from you on rebuttal in a moment. Counsel?
Thank you, Your Honors. Michael, may it please the court, Michael Hannon on behalf of interested party Serengeti Asset Management. The Article 77 proceeding below presented a question concerning the distribution of sale proceeds that, as Judge Manzanet pointed out, is very literally answered by the plain language of the contract. Section 12.1 of this indenture is entitled Sale of Collateral Debt Securities. It states precisely how and precisely when the proceeds of those sales should be distributed. It says all proceeds will be deposited in the collection accounts and applied on the following quarterly distribution date succeeding the end of the due period. Interpretation of contracts, including the indenture at issue here, begins and ends with the plain language, which is dispositive here. Now, the decision below demonstrated how and why this plain language fits the contract on the whole, and why my client's interpretation is the only one that gives force and effect to each provision. The decision below wrestled with all the provisions that my colleague Mr. Sullivan is pointing out and explained that those other sections, 10.2G and 11, they provide for the transfer and payment of funds only with respect to the related due period, and that the due period depends on the distribution date and whether it's quarterly or monthly, and that because sale proceeds are applied on quarterly distribution dates, they remain in the collection account for the duration of the due period relevant to the quarterly date. So the court's thoughtful analysis showed how these provisions work together and explains why PIMCO's interpretation is wrong. And what's really remarkable about PIMCO's briefing is that they seem to ignore the lower court's analysis entirely. PIMCO has never, to Judge Liggett's question, offered any interpretation of the indenture that affords meaning to the decisive language in Section 12. Section 12 is not permissive, it's not optional, it doesn't say maybe or can be, as PIMCO suggests. It says what we've already talked about, and as further proof that the rule was intentional and mean what it says, you can compare the language of the rule that we're talking about, the sale proceeds distribution rule, to very different distribution rules elsewhere in Section 12, which apply to distributing sale proceeds that were received 10 years ago, prior to 2012. Now, those rules, those different rules not applicable here, say that the proceeds of these early sales get transferred to the payment account, not the collection account, and they get distributed on the immediately succeeding distribution date, not the quarterly distribution date. And so, in other words, the drafters of the indenture here, they contemplated the very distribution rule that PIMCO advocates for. They used it elsewhere in the indenture, but they left no doubt whatsoever that it doesn't apply here. And so this is a straightforward appeal. The contract answers the question at issue. The appellant has no response to the lower court's analysis, and the appellant offers no workable construction of the contract on the whole. The lower court's decision should be affirmed. Thank you.
Am I correct that the 10.2 provision speaks to the transfer of the monies into a different account as opposed to the distribution of those proceeds?
That's correct.
Okay, thank you. All right. Counsel, we will hear you on rebuttal.
Couple of points. Section 10.2G refers to the transfer of funds from the collection account to the payment account. Section 11 then deals with the payment account and says once it's transferred to the payment account, the funds have to be dispersed on the next distribution date. The way these indentures...
But wait, Section 11 doesn't that break down based on whether it's a monthly distribution or quarterly?
It does distinguish between monthly and quarterly.
Okay.
And it says in the lead into section 11.1, on each distribution date, the trustee will make the following distributions. So on each distribution date, the trustee has to look at whether it has to make distributions. So the way 10.2G works is it transfers money to the payment account. Section 11.1 then requires the trustee to make a distribution on each distribution date. The way Section 11 also works is that the most senior note holder, in this case PIMCO, negotiated and bargained for higher protection, which means it gets paid on a monthly basis. It received less interest so that it would get paid on a monthly basis. And the Second Circuit, when it was considering Section 12, said that Section 12.1, which is the sale provision that counsel is pointing to, Section 12.1 is designed to protect the most senior note holder in the event of deterioration of the CDO. The sale proceeds that are at issue here are the result of the sale of defaulted securities. And so the Second Circuit has already held that the most senior note holder should be paid first in the event of devaluation. So what Section 11 does is it says that you, the most senior note holder, the person who is...
What do we do with 12A5? All of your argument completely ignores that provision. Completely.
Your Honor, are you referring to Section 12.2A?
You know exactly which section I'm referring to.
I take you to be referring to Section 12.2, where you refer to the applied on a quarterly basis.
12.1A5, AV.
Okay, 12.1A5 refers to retained uninvested funds during the reinvestment period. That reinvestment period has ended. It ended in 2012. Section 12.1A5 refers to the word retained. Section 12.1A, the general portion that Mr. Hennin is referring to, that does not use the word retained. And it is also a principle of contract law that if you use the word retained in one place in the exact same section, but don't use it in another place, that omission was intentional. There is no reference to retention in 12.1A. What 12.1A also says that is that
Counsel,
it only...
let me just stop you because you're running out of time. These proceeds were not reinvested, correct?
These
This
proceeds
is a
were not
simple yes or no
reinvested.
answer. Were the proceeds reinvested?
No, because it's impossible.
So if they were not reinvested, then they had to be distributed according to subsection 5. No?
Correct. They had to be distributed according to subsection 5.
All right. Thank you. We have your briefs and your arguments.
Thank you, Your Honors.
Thank you.
Thank you. All right. Want to make sure I don't make the same mistake again. Board of Managers, Alfred Condominium versus Miller, followed by Miller versus Alfred Condominium. I will hear Mr. Greenberg first for 4 minutes.
Yes, thank you. So Philip Greenberg, attorney for defendant appellant James Miller. In the lower court, Mr. Miller asserted counterclaims which were clearly sustainable for breach of the fiduciary obligation of the board and met all the requirements for that. He also alleged that there were illegal conditions in the building, conditions which he complained about, and the building was fined. And as a condominium owner at the Alfred, he shares in the damages from that. Because he has been a, quote, whistleblower at the building management and the board used Building Link in order to defame Mr. Miller. Among other things, they said that he had false...
I just want to ask, with regard to the individual defendants, were they served?
No, that's the next case, Your Honor.
Oh, I'm sorry. Okay.
Yeah, there's only one individual defendant here, my poor Mr. James Miller.
Okay.
and that all the requirements for defamation were met in that they made these false allegations, such as they claimed, among other things, that Mr. Miller had made false complaints to city agencies, notwithstanding the fact that there were fines because of those illegal conditions. They claimed that he impeded employees from doing their job. What Mr. Miller tried to do is try to stop the building from having the employees illegally park in front of the building, in front of the fire hydrant, and preventing first responders from coming into the building. And then the fifth cause of that, the fifth counterclaim, had to do with the fact that in retaliation for Mr. Miller's complaints about the dangerous and illegal conditions in the building, somebody piled feces on top of his bicycle, and the building, the plaintiff here has the videotape showing who did it, and they've refused to turn it over. They even denied the request of the local police captain to turn it over. Now, Justice Ostrager, remember, this was a 32-11 motion to dismiss. This is not a summary judgment motion. Justice Ostrager, in a one-line handwritten decision, said he's dismissing all the counterclaims. This court, under the case law, should make a de novo hearing. The counterclaims clearly allege breaches of fiduciary obligations, of defamation, and of good faith. And it was clearly erroneous by Justice Ostrager to dismiss the counterclaims on the face of the pleadings.
Okay. I'll reserve the rest of your time for rebuttal.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the court, Maria Boboris for the respondent. I want to first start with the defamation claims. What counsel has failed to notify the court of is that all of his purported defamatory statements alleged in the complaint are actually allegations that the board has lodged against his client in the complaint in this action. They were never published on Building Link, and even if they were, they would be privileged under the litigation privilege, which is an absolute privilege. In addition to that, there's also the common interest privilege, which applies here because the communication, as alleged in the counterclaims, was communicated to all of the unit owners. Additionally, the defamation claim is not pled with the requisite specificity. The allegations are paraphrased. The alleged libelous statements are paraphrased despite the fact that appellant would have had access to the Building Link posts he complains of and could have pled the specific words, but he doesn't. And that's in a apparent attempt to evade the absolute privilege.
I'm more interested in the breach of fiduciary duty claim. So why don't you address those?
Sure. There's two breach of fiduciary duty claims. One is speaking generally that there are various, illegal conditions and fines from various, agencies. It doesn't identify who the agencies are, what the fines are about, what the alleged violations were, and that does not meet the pleading specificity for a breach of fiduciary duty case. The other one here is that Mr. Miller was banned from the gym, and he does not, appellant does not argue that the board did not have the authority to ban him from the gym, but argues that they did so.
Why is there not an issue of fact about whether that banning was not retaliation for his complaints about the gym?
Well, Your Honor, there's documentary evidence.
I mean, it seems like it to me.
Well, I'll go back. I mean, it's the documentary evidence is not just the complaints that have been submitted by the management company, Elite, and other unit owners. It's Mr. Miller himself admits that after the board sent him a cease and desist letter stating not to take pictures of residents unless they have the express permission to do so, Mr. Miller went and took a picture of an underage lifeguard using the pool and sent it to the board and admits he did so in his papers. And also there's an email stating, and the condo has the right, the board has the authority to set the conditions for using the gym. And the condition that it sent is not taking pictures of individuals as they utilize the gym, which is a common practice throughout gyms in the city. They did not bar him from taking pictures of the pool if it was empty or the spa if it was not being utilized. They specifically said, do not take pictures of any residents as they're utilizing the gym unless you have their express permission. He did not have the express permission of this particular youth using the pool, and her parents were obviously upset, and he refused to delete the picture when asked to. In addition to his admission, there are written complaints that are in the record from the management company threatening to terminate their contract with the condominium due to Mr. Miller's complaints. Not complaints, he has been harassing lifeguards and has been people have been asking to be transferred and do not want to work in the gym. And that has created an obstacle for the staff and impedes on, you know, the other unit owner's right to use the pool. If the pool cannot be staffed with a lifeguard, it must be closed. So
Okay.
Perhaps one of those individuals who was complaining retaliated by putting feces on the seat of his bike.
Well, Your Honor, the video was viewed, the bicycle was outside of the building across the sidewalk. It wasn't in view of the cameras.
So if that is true, then why not provide that to the police department?
Well,
that to me, counsel, is outrageous. Outrageous.
I understand, Your Honor, and I will say the police have come to this building along with the fire department and every other city agency multiple times because Mr. Miller calls them to the building. So the police officers that showed up on the scene. What does that have to do with, what does that have to do with what I am saying? Okay, somebody improperly put feces on his bike. And whether the people at the building and the board and anybody else there thinks he deserved it and too bad, good for him. I don't understand why the police department allowed your people to obstruct an investigation. They asked for the video and then winked and said, you don't have to turn it over without a warrant.
They winked. Oh, I'm sure the police department loves what you just said on this argument. I'm sure they're gonna love that.
Your Honor, look, whether or not the court agrees or disagrees with the board's actions, the bottom line is it's not a breach of a fiduciary duty. It's not a cognizable claim. The board doesn't have an obligation to hand over video, which, by the way, I'm sure there would be plenty of unit owners that would not want video of them walking in and out of their building turned over to the cops without a warrant. That's what warrants exist for, Your Honor. And there was no, again, it was viewed.
If I may.
Sure.
So you're then agreeing that this should survive the motion and proceed to discovery, right?
No,
to
I'm
determine
not.
whether or not, to determine whether or not the surveillance tape should properly be turned over and perhaps even viewed in camera.
No, what I'm saying is there's no obligation on the board to turn it over. There's no legal obligation, and plaintiff appellant has failed to identify any obligation on the board's part to turn over surveillance video. And if
but counsel, this is surveillance video for a specific reason, right? Confined to a specific incident, not all surveillance video, not things going on in the pool or the spa, but rather related to a discrete incident which had to do with the bicycle.
Understood. And, I understand Your Honor's, gripe with the board not turning it over. Going back to where
I don't have a gripe.
I understand. I don't think that this should go back again. Like the police could have issued a warrant if they wanted to see the surveillance video. And there is no obligation on the board's part to turn it over.
Well, putting aside, whether they have a fiduciary duty to turn the tape over, the tape, given the procedural posture of 3211, the tape may have conclusively resolved one or more aspects of the case, but we don't know what's on the tape, and so there's nothing the tape, at this juncture could resolve.
Well, even without the tape, Your Honor, the pleadings themselves are deficient. They don't allege that the board Initially, this is one of the ones that overlaps between the two. They're alleging civil conspiracy, that the board conspired with some unnamed Doe, and the only overt act that the board took was after the fact by not turning over surveillance camera to.
It just makes me wonder whether one of the members of the board is the culprit. Okay, you know, you don't turn it over and you leave this air of suspicion out there, but you know, your company has decided to do what they think is right, and that's that. All right, Mr. Greenberg, I will hear you.
Yes, thank you. I'll be very short. So with the assistance, with all due respect, of Ms. Barbaros, we've shown that there are numerous questions of fact here. And I remind you, it was a 3211 motion. It was just directed at the pleadings. So what Ms. Barbaros has helped to establish is that there are a lot of factual issues that are going to require discovery and a trial. I don't even think they would be able to succeed on a 3212 motion, but this is a 3211 motion just at the pleadings. The one thing I'd want to say about two things. On the defamation.
Counsel, you have 1 minute, and then we're going to the next appeal.
Okay,
so
I'm going to make 30 seconds on each. 30 seconds on defamation.
You've already used 30 seconds, so you have 30 seconds left.
Okay. Defamation, we met, as we showed in the reply brief, we've met the requirements for a defamation case, and in terms of the photographs, we'll stand on the briefs and the record, and we ask the court to reverse the lower court. Thank you.
All right, why don't you proceed with your next appeal?
Good afternoon, and may it please the court. I don't want to belabor the point that Mr. Greenberg's made already quite eloquently, but this was a motion to dismiss under CPLR 3211. The trial court didn't give notice that it was treating the motion as one for summary judgment. And in fact, the standards that it articulated were not the summary judgment standards. And yet that's the heightened sort of standard.
Okay, counsel, on this case, this is the case where the individual defendants were not served. Am I correct?
Some of the individual defendants were not served.
Only 2 have been served individually, correct?
That's correct, Your Honor.
Everyone else has not. So why is that portion of the court's dismissal incorrect, especially since your client was kind of highlighted that there was a lack of service the last time?
So number one, Your Honor, it shouldn't result in a dismissal with prejudice as to the defendants that were not served. That's number one. Number two, there, as Your Honor points out, some of the individual defendants already, in fact, had been served. So at bare minimum, Mr. Miller's claims as to those defendants should proceed. And again, even as to the other defendants, dismissal should not be with prejudice, but should be without prejudice.
Okay.
And you know, the trial court faulted Mr. Miller in its decision for not adducing proof of his allegations. But proof isn't what's required on a CPLR 3211 motion. Allegations.
Except that on a defamation, are we talking about the defamation claim?
No, Your Honor. Our claims here are at their core. They are, as you pointed out, Justice Manzanet, they are breach of fiduciary duty claims. That's what this case is about. That's what the counterclaims in the other case are about. This is all about a breach of fiduciary duty. And in this case, as in the other case, Mr. Miller has alleged specific and detailed instances of breach of fiduciary duty by the board. Those allegations are far more than what's required to give notice under the CPLR's low standard for dismissal at the pleading stage. And, you know, even though the trial court seemed to harp on the business judgment rule, the business judgment rule actually supports defeating a motion to dismiss here, because the business judgment rule says that when the plaintiff pleads that the breaches of fiduciary duty were not taken in good faith, or they were discriminatory, or they were retaliatory, as Mr. Miller has alleged over and over again in his pleadings, the business judgment rule, not only does it not support dismissal, it actually buttresses the claims. And I would respectfully point the court to last year's decision in Johnson v. Asbury. I believe, Justice Gonzalez, you were on the panel in that case. And in that case, this court held that it is the consummate question of fact that cannot be resolved on a motion to dismiss under CPLR 3211, where the plaintiff alleges that the actions of the board are taken in bad faith, or they're discriminatory, or they are retaliatory. That's what this case is about at its core. I don't even need the rest of my 4 minutes. Respectfully, we urge the court to modify or reverse the trial court's order. Give Mr. Miller his day in court. Give Mr. Miller the opportunity to prove his claims in discovery, which he will. Thank you.
Thank you. Counsel?
Your Honors, there are no allegations of discrimination, retaliatory intent, or bad faith with respect to the majority, with all but one of the breach of fiduciary duty claims, and the one being the gym membership, which we've discussed in the prior case. The majority of the breach of fiduciary duty claims against the board are brought derivatively, and appellants have failed to address the fact that they did not plead demand futility in their second amended complaint, just like they hadn't in their first amended complaint, despite the fact that the court gave them the opportunity to do so. There are no allegations of bad faith. There are no allegations of discrimination with respect to all of those claims. And there's no discussion of how all of the complaints that Mr. Miller has amount to a breach of a fiduciary duty. For instance, maintaining the gym at a temperature that's not to his liking. That is one of his derivative claims. They're not pled with the requisite specificity to survive the business judgment rule. Again, I will reiterate this because it's worth saying, there is not a single allegation of bad faith with respect to any of the derivative claims which make up the basis. The only claims of discrimination, again, are to the gym, and what appellant argues only an appeal with respect to the alteration agreement, which are temporally impossible. The alteration agreement was a breach of contract claim. They failed to also add the condominium, another defect that they failed to remedy after the court pointed it out. Those claims were dismissed, and now appellants are arguing that they were made to undo channeling in his apartment as retaliation for bringing these claims. If you look at the complaint, temporally it does not make sense. Appellant had finished his alterations before he started lodging his complaints to the board. The alterations were done in 2017, and he started, by his own admission, alleging complaints to the board in 2018. And again, there's no basis to even allow him to replead and to add the condominium because he has not demonstrated a breach of the alteration agreement. He channeled into his unit in contravention, into the concrete slab and the rebar of the building in contravention of the alteration agreement, and then complains that his alterations were delayed because the board made him undo the work that he admits was done and concedes was against the alteration agreement, but claims that, you know, they were treating him differently, despite signing a contract saying that he was not going to do this. So no, the judge did not apply a proof standard. He said that appellant failed to demonstrate with the requisite how any of his gripes, and by the way, appellant's counsel represented to the lower court that the majority of these claims were gripes. That is a word, and I'm quoting Mr. Colbray saying in front of the judge, and that's exactly what they are. This is a unit owner that wishes to run the building in a manner that he sees fit. And again, he has not made a single allegation in this complaint that amounts to a breach of fiduciary duty or that's a cognizable claim that should have survived dismissal. And he was given multiple chances to amend his complaint. This was the third complaint that was filed, and yet still has the same exact defects in this complaint, which is why he shouldn't be allowed to replead, because it would be futile, and he was given the chance.
Thank you.
You're welcome.
All right. Mr. Colbray, you have 1 minute.
Thank you. Just 2 or 3 very quick points. My friend, Ms. Barboris, says that Mr. Miller hasn't alleged a single instance of discriminatory or retaliatory breach of fiduciary duty. There are plenty in the complaint. I would respectfully point the court to page 15 of the record, paragraph D, where Mr. Miller alleges that even though he was required to undo certain of his alterations in similar or exactly the same circumstances, other unit owners were not required to do so. That is discriminatory treatment, and that defeats any claim of the business judgment rule. Ms. Barboris points out that that I used the words gripe before the trial court at oral argument. That's true with respect to some of them. I think with respect to the temperature of the pool, that is a weaker claim of Mr. Miller than other of his claims. That does not mean that his stronger claims don't survive the motion to dismiss and its very, very low pleading standards. Mr. Miller clearly has alleged breach of fiduciary duty. And, while some aspects of the complaint are pleaded more artfully than others, the case needs to proceed on his allegations, which must be taken as true at the pleading stage.
Thank you so much. Thank you all.
Thank you.
Last but not least, Posner versus Posner. Mr. Hiller, you have 5 minutes. Mr. Miller, if you are speaking, we don't hear you or see you.
And yet there I was. Sorry about that.
There you go.
And again, I was so good at the beginning. May it please the court, Michael Hiller, PC, on behalf of Executor, Appellant, Cross Respondent Robert Posner. As I'll discuss in a few moments, the lower court should have granted summary judgment with respect to the objection to Mr. Posner's acceleration and full payment of a promissory note payable to the estate. The lower court committed error of law by reversing the burdens of proof and imposing upon the executor the obligation to prove his good faith when the standard for determining the propriety of an executor's resolution of debt payable to the estate was established in the estate of Leopold. And in that case, the court made clear the burden is on the objectant to prove bad faith or fraudulent misconduct. And that standard is especially applicable here insofar as the executor.
Counsel, Judge Oing has a question.
Oh, I'm sorry, Judge Oing.
Can you hear me, Mr. Hiller?
Yeah, I can hear you.
Okay, so the question I have in this case here, the father gave the executor a note. Right?
Yes, you are freezing a bit, so I'm having a little trouble.
Yeah, we have, Judge Oing, there's a little feedback going on.
Hang on, I'm sorry. 1 second. Let me go back. Let me go back to these things.
Okay.
Okay.
All right. So the father gave the son a note for the money the son loaned to the father, but the note didn't have any prepayment. There was no acceleration of the note, and that's why is that not a problem? That he accelerates the payment and he takes the money. It's like $200,000-$300,000 worth.
There's several reasons why that's not a problem. First, the promissory note in question did not have any preclusion provision against prepayment, but that's really not.
Well, that's kind of circular. It doesn't go one way or the other. It's silent, right? I mean,
well, but I would think that if there were a preclusion to prepayment, that would be one thing, but there wasn't. But I would agree with you. That's only a partial answer to your question. The second answer to your question is that in this particular instance, this particular debtor, who happened to be the executor, had defaulted multiple times in making payments. Meanwhile, it's an 11-year payout with a $303,000 balloon in year 11 when my client would have been 73 years old, suffering from Parkinson's and unemployed and unemployable. Under those circumstances, it's entirely reasonable for an executor to say, you know what, rather than dragging this estate out for 11 years, let's marshal the assets of the estate and prepay the note and accelerate the note. And I would point out to you, Justice Oing, that there was a companion note here, and it was to the brother. And the brother's.
Well, that had an acceleration clause in that. That note had an acceleration clause. Did it not?
I don't believe it did.
Or default provision.
No, I don't.
It got accelerated pursuant to a default.
Right, just in the same way that my client had defaulted on multiple occasions, and that is in the record. And the fact of the matter is,
well, your client is you're in a unique situation. Your client wears two hats, right?
Yes.
He's the executor and he's also the creditor, right?
Yes.
So when you say that he defaulted, he really defaulted on himself. I mean, it's kind of like, I had I had to draw a flow chart to keep straight who's defaulting where. So when you said that he defaulted, I mean, was there, could you point anywhere in the note that says that once you default, he's allowed to accelerate the payments?
Well, of course, and at record 117, you will see that when you default under the promissory note, you can accelerate the note. And furthermore, Your Honor, that's exactly what happened when the trust, the brothers' trust defaulted under the note. My client accelerated the note, had to sue, obtained the acceleration, and the note was ultimately paid. And one matter that I believe, with all due respect, you overlooked is the fact that in this particular instance, the executor, before accelerating and then obtaining prepayment of the note, contacted the estate's attorney. And the estate's attorney, who had been there for 10 years.
Yeah, but he passed away, so you really can't, we can't rely on that. I mean, that's also, you can't, the attorney's advice to him, I mean, that doesn't, that may, you know, that's kind of, it's not written down anywhere. He's saying that the estate's attorney told him to do this, correct?
If you look at record 220, you will see that the lawyer in question actually billed for the time, devoted a half an hour to that conversation, and then the prepayment occurred shortly thereafter. So I would.
Well, we don't know.
But that doesn't mean that it was his advice.
Yeah, we don't know what happened.
It could mean that they had the conversation and that was your client's idea and he carried it out.
And the attorney could have said, yeah. And the other thing is that, and any good attorney would always, in a sense, say, look, well, yeah, maybe you could do it, but there may be other problems. We don't know what transpired in that conversation. Just because it was a billable time for it doesn't mean we don't know what happened.
Well, Your Honors, you do know what happened if you accept the affidavit and the deposition testimony of Robert Posner. And I would point out to this court that in Hernandez versus Ortiz, 165.
Mr. Hiller, I got to tell you something. Something would have been very simple, is that he should have gone to the beneficiaries and say, look, I'm doing a prepayment. And then the beneficiaries would have said, okay, fine. Yeah, that's a good, Uncle Rob, that's a good thing. Go ahead.
Your Honor,
you know what? You wouldn't even have this lawsuit right now.
Your Honor, I can tell you this. If my client had not accelerated the note and prepaid it, we would be here today with the defendants, the respondents saying, the objectant saying, you know what? You should have forced yourself to prepay the note and you didn't. You treated us differently, because when the trust defaulted and they accelerated the note, when that happened, my client, when they defaulted, my client accelerated the note and forced prepayment. That's what my client did. When my client defaulted, if he takes a different...
Mr. Hiller, your client accelerated the payments on his brother Paul, right?
Yes.
And brought the lawsuit against him when Paul didn't want to turn it over, and then it went on and on and on. Correct. But he didn't, did he default himself too? In similar vein?
When you say did he, who's the he in that? My client?
Sorry, your client. Did he default himself?
Yes, but not intentionally. He just had trouble making payments.
No. Sorry, I didn't mean it that way.
Okay.
Not did he default. Did he default himself? Did he proceed against himself the way he proceeded against his brother when his brother defaulted?
No, he didn't file a lawsuit. He contacted counsel and asked what he should do. I should emphasize that if he had filed a lawsuit, it would have cost the estate hundreds of thousands of dollars, because the notes don't have...
I'm glad Justice Gonzalez mentioned that, because it just brought to mind a question. When he went after, when your client went after his brother Paul, he was recovering monies for the estate,
right?
Correct?
Absolutely.
So that the beneficiaries would not be complaining about that, because he's actually bringing money back into the estate. In this case, in your client's case, the money is coming out of the estate. It's going outside of the estate to pay back a note that your client is owed. So there's a big difference there, no?
There is no difference whatsoever. These notes are identically written.
Mr. Hill, I understand that, but you're not, but the difference is money coming into the estate versus money going out of the estate.
No, with all due respect, Justice, that is, I'm sorry, but that's not correct. I hate to say that, but it's just not correct.
No, it's okay.
There are two notes here. They're identically written. Note A, let's call Paul's note A. Under Paul's note A, he defaults. My client accelerates, obtains prepayment, gets the money into the estate. My client defaults. My client accelerates the note, obtains prepayment into the estate, it's the identical circumstance. And in fact, it is entirely consistent with what the testator intended. I should emphasize too, these two notes were for the
All right,
purpose.
counsel, I'm going to stop you there because we have way exceeded your time and you can say whatever you want to say on rebuttal. Counsel.
Your Honors, may it please the court, Michael Chiaffa for the Posner grandsons. Not arguing the case with regard to Brother Paul. Brother Paul and Brother Robert have a long history of animosity between each other. But Uncle Robert had a fiduciary duty as the executor of the estate to the grandchildren as the beneficiaries.
But sir, wasn't that duty defined and if you will, curbed by the exculpatory clauses in the will?
Your Honors, that's an excellent question. Even if Uncle Robert was a stranger to himself, if he, as executor, gave up a right for $300,000 in interest on a non-prepayable note that was payable with that interest over.
There is no statement anywhere that makes these notes not prepayable. Nowhere.
Your Honors, there's a finding by the surrogate that this was not a prepayable note, and there was litigation below, not contested on this appeal, by Uncle Robert, that this was not a prepayable note. If the court wants to take judicial notice of the record before the surrogate, there was briefing below on this issue and has not been.
Is that in a written decision somewhere?
Yes. Yes, Your Honor.
Which one, so that I can find that language?
Sure. That's an easy one. The court's decision, Surrogate Anderson, is at pages 5, etc., on the record. And
on page what?
I'm sorry, it starts at page 5 of the joint record. If you look at page 8, this is the second paragraph under discussion. The threshold issue on these motions is whether the note gave Robert an option to prepay. And the surrogate goes on, if the terms of the note allowed Robert to prepay, then the executor, the same person, Robert, was obliged to accept the prepayment and as a matter of law cannot be surcharged. If the note did not so provide, however, then the issue becomes whether the executor's decision to accept the prepayment and forego the estate's receipt of continuing interest payments was a breach of fiduciary duty. The surrogate goes on, there's no dispute that the note did not include an express prepayment provision. Significantly, the estate does not argue that Robert nonetheless had the right to prepay under the terms of the note. The reason is clear. There is no legal basis to read such provision into the note. And then goes on to the carryover paragraph.
But counsel, if I may, at record page 11, the court said it couldn't conclude that the executor acted in good faith in accepting the prepayment without evidence of Robert's financial condition. So would you agree that there's an issue of triable fact here as to Robert's financial condition?
No, Your Honor, for a number of reasons. First of all, Robert was a half beneficiary of the will in the estate in this case, which by Robert's own accounting was worth more than $1.5 million, which was ample.
But that would have been so for Paul also, no?
Yeah.
Okay. So yeah. Why is it so impossible for Robert to have an issue when we know Paul did?
Your Honor, I really don't understand your question. The question was.
Well, my question is, you say he's not financially, there's no issue about whether he had financial means because he got $1 million from a portion of this inheritance, but so did Paul, and he defaulted. So the fact that he got $1 million is certainly isn't a proof of that fact that at that moment when he prepaid, he still had those funds.
Well, he had enough. He had enough to prepay the principal balance plus interest to that date, and he did not submit a single bit of financial information, which the surrogate cited in her decision as the absence of proof. Who better than Robert had the ability to show what his financial means?
Why is that argument not the same for? Why is that consideration not the same for Paul, seeing as Paul had to defend against the action, which I presume was not for free, and ultimately had to pay the interest and the lump sum payment as well? So why was it okay for Paul to do it, but not for Robert?
Okay, the only reason that Paul did not have to pay all the remaining interest was that Robert made a decision for his own reasons to accelerate the debt, which cut off the remaining interest under the note. If you look at the terms of the note, as the surrogate found, once there was an acceleration and there was a acceleration and payment of the entire balance plus interest due to that date, that extinguished the brothers Robert's, Paul's obligations under the note. In this particular case, Robert did never.
So that means that Paul defaults and saves money and interest payments because of his default. Because the interest payments run only up to a date certain, and Robert says, I want to do the same thing. I want to save on interest similarly. So I'm going to prepay. And you see a problem with that.
I certainly do. Robert did this covertly in 2003. And 11 years later, he filed an accounting that disclosed for the first time what he had done. He did not accelerate by any traditional means. He just decided that he was going to shift the money from one side of the balance sheet to the other. And
well, sir, because I know we're running out of time here, I want to get back to what I think is really at the core of this appeal, and that is the exculpatory clauses. So let's assume in your favor that Robert did not have the right to prepay, and yet he nevertheless did. Why, in light of the exculpatory clauses, did he not enjoy that, discretion, if you will, to do that?
Well, because he had a duty of good faith and fair dealing that he did not satisfy. All of his excuses were rejected by the surrogate one by one. He wanted to clean up the balance sheet, that he did it because his brother was able to get away with it. He relied on the advice of counsel that there's no record of any advice given. All there was a half an hour conversation. It's all self-serving stuff that's not within the grandson's ability to prove. It's all based upon Robert's say-so, and he shifted money, $300,000 that belonged in the estate, to his own pocket, just by an ipsa dixit, without any proof, without any justification. You look in the surrogate's decision. You look far and wide why the surrogate found an issue of fact here. I just don't see it. All the facts are undisputed. They all point towards bad faith as a matter of law. The Jastrzewski case that the other side relies on, there was affirmative evidence that the executor in that case had good reason to buy out an insurance policy. It made financial sense.
Mr. Chiaffa, this is Jeff Doyne. So you
Yes,
just said something. You just said something that I think corrected Mr. Hiller, and this was. I thought my position was that money was going out of the estate when the prepayment was made. But Mr. Hiller was telling me that I was incorrect in saying that there was no money going out of the estate. You just said that money was going out of the estate. It was going into Mr. Posner's pocket.
In effect, that's what happened, Judge. He owed $300,000 at the 9% interest rate over a period of 9 years that he avoided. In effect, he took that money that belonged to the estate and should have been
Okay.
accounted for and
And
put in
that,
his
and he took it personally into his bank account, into
Yeah,
his pocket.
same-
Okay. I
Same
got it.
person,
Okay.
same person.
All
Uncle
right.
Rob.
Thank you.
you so much. We have your
Thank you.
brief and your record.
I have
Mr.
a,
Hiller, you have
Thank-
1 minute.
sure.
And I
Just-
mean 1 minute,
You have that.
okay?
So first of all, when we talk about the grandsons, I hope that no one's taking these like 6-year-old kindergarten boys in school. These are 40, 50-year-old men. I just want to make that clear. With respect to the advice below, I want to emphasize that the objectants did not argue below that this advice had not been given by the lawyer. They argued instead that the advice that was given was business advice and therefore not protected under the lawyer's advice rule. That's a critical fact here, because all of the issues you talked about, we don't know, that argument was not made below. Secondly, these notes were companion notes, and I'm sorry, I beg to differ with my colleague. These are two identical notes, identical payment formulas, and each note was designed to provide a 50% acquisition to the family property. So when Paul prepaid his note, you can say it any which way you want, but if he was pulling money, if he wasn't pulling money out of the estate, neither was my client. If Paul was pulling money out of the estate, then I guess my client was too. But the point is, as an executor, these men and women who are executors are marshaling the assets of the estate. If he hadn't done this, it would have been an 11-year payout. The estate would have had to stay open 11 years with a $303,000 balloon payment at the end. And I disagree with my opposing counsel about what the surrogate supposedly found on page 8 or 9 of the decision. There's no case citation there. I've seen many cases over the years that say that when it says you cannot prepay, you can't prepay. I've
So
never.
I just want to ask you one thing to go back to something I think you said at the very beginning of your prime argument, your main argument. Are you arguing or are you suggesting that the proper standard in light of the exculpatory clauses for any liability on the part of Robert would be the standard articulated in Leopold's estate, and the more, I guess, modern phraseology might be in Jastrzemski from the Second Department, the bad faith and related type conduct?
Absolutely. And if you think about it, an objectant in this circumstance is acting as if a counterclaim plaintiff or a defendant asserting an affirmative defense. They've got to come forward. Otherwise, every executor is going to have to justify every transaction they're involved in. They've got to come forward with some modicum of proof that my client's acceleration of a promissory note, just as he had done for his brother's note, under the same circumstances, was in some way a breach of fiduciary duty. Under those circumstances, I really beg to differ with my colleague, Mr. Chiaffa. These men were being treated the exact same way, and my client was doing his best. And the last point I'll make before I finish, and I appreciate the time, is I just want to mention to the court, these exculpatory clauses are very broad. They ask for even opposing counsel points out, it's the maximum leeway available under law. And at record 158, I believe it is, paragraph 12, it says very clearly that when you look at this circumstance, you are to consider the executor's actions as if you were a stranger to the transaction. So when you go back to your room and you decide this case, the will asks you to consider would it be unreasonable? Would it be a breach of fiduciary duty if a stranger had come in, looked at these circumstances, seen Robert's prior defaults, just like Paul had defaulted, the fact that there's an 11-year payout, he has Parkinson's disease, it's a $303,000 balloon payment at the end of an 11-year term, and during that 11-year term, only $10,000 a month are coming into the estate. Would it have been better to marshal the assets of the estate under those circumstances, or was it a complete breach of fiduciary duty? Bad faith, how could he possibly obtain full prepayment of both notes? I respectfully submit the court should have granted summary judgment to Robert and allowed the estate to close. And with that, I thank you very much for your time.
Thank you both. This ends the session of the Appellate Court, First Department. Have a good evening all. Stay safe, everybody.
Thank you.